হ্যাঁ, অরিজিনাল সাইড, হ্যাঁ। স্লিপ। ঠিক আছে, ঠিক আছে। কমার্সের এগুলো দুটোই আছে, হ্যাঁ? ওখানে সুইচ দেওয়া আছে ভিতরে, ভিতরে ভিতরে। না না, উপরে উঠেছিল, উপরে। এ নিয়ে ওঠে।
সুগত মজুমদার তো স্যার।
হুম হুম হুম, সুগত মল্লিক। এক পাতা মনে হয় কমার্শিয়াল আছে।
नहीं हो रहा है फिर। अभी तक तो जजेस भी कंप्लीट नहीं हटा रहे। 80 जजेस भी हमारा
তিন কপি বার করবো তাই তো?
হুম হুম হুম,
দুটোই?
দুটো, হ্যাঁ। তিনটে তিনটে সেট বানানো। কমার্শিয়ালটা দাওনি, দিয়েছো? তিনটে কমার্শিয়াল বার করে নাও আগে, তারপরে।
ना आया नहीं। हाँ, तो वही डाले थे। मैं तो इस तरफ में रख देना होगा।
जजेस भी इसलिए हमारा डॉक्यूमेंट में देना पेंटिंग sort of put on sites if they are going to ask what last time order
হচ্ছে না।
26th. Regarding the Shoaib, I can remember. Then 20. Tomorrow I will fix a date. 21st,
21st.
Any day
or
as per your
22nd.
Any day as per your
Let me check the diary.
Deeply obliged.
Almost finished. Argument is almost finished.
Any other mentioning?
যদি হয় কালকে লিস্টে যেরকম আসার আসবে আসলে আমি একটা পরশু ডেট দিয়ে দেব।
Original Side Commercial Division, item number 1, Blue Star Limited.
I appear for the plaintiff. On the last occasion,
I
your
appear for the
lordship has
defendant.
granted us leave to amend the plaint. Now that amendment has been carried out as per your lordship's direction, and a copy of the amended plaint has also
Yes,
been
my lord,
served.
I have received.
Additional written statement.
My lord, we shall file an additional written, but my lord, ideally there is no need to file an additional written statement because the amendment is only to the regard that the original site suit was converted to a commercial site suit.
Only this session.
Yes, my
And
lord.
the name of the company, the plaintiff,
Yes.
that has changed. So,
So I am not fixing any date for additional written
No, my-
statement.
But my lord, I would request accommodation for a fortnight because the problem is, my lord, this is a PSU. I am appearing for national insurance. My lord, the entire brief of documents has not come to me. I have sought my learned friend's help to take copies from his brief because the judge's brief of documents has also to be compiled. The defendant's documents are still pending. So, my lord,
my
if I
lord,
get a
what has happened, I tell your lordship, on the earlier occasion, by order of the court, we had prepared the plaintiff's judge's brief of document. Now that is lying ready with me, although it is in the old format, in legal format. So if your lordship grants me leave to file that way, I can file it right now. Plaintiff's judge's brief of document. Now after that, they have to file their document, and thereafter the compilation of the judge's
I
brief.
am fixing it for framing of issues.
my lord,
Come on the next date
my lord,
with all your documents, judges brief, so and so,
my lord,
and suggested issues.
my lord.
My lord, but before that, the judge's brief has to be
In the
filed.
meantime, these things will be done.
Very well, my lord. We shall.
We do not like to waste time.
No. I also trying to make that submission, my lord, that if we shall do that. Only thing that if they can produce the document, their document, so we can prepare
Please
the
do that.
compilation of.
Once at least I get the affidavit where I have disclosed documents from my learned friend, I can pursue the PSC to
All right.
file the original documents, my lord.
An accommodation is sought for. না এইভাবে দেখো the learned counsel for the plaintiff submitted that amended copy of the plaint has already been served upon the defendant. Full stop. The learned counsel for the defendant submitted that there is no need to file additional written statement as the amendments were formal in nature. Full stop. Fix so and so for framing of issues. Judge's brief of document is to be filed in the meantime.
My lord, may I make one submission, my lord? My lord, as I prayed before your lordship, my plaintiff's judge's brief is ready with me, my lord. If your lordships grant me leave to file it in the old format, then I can file it before your lordship.
Come with the new format in the meantime.
Very well, my lord.
Let the suit appear in the list on 7th March.
My lord, may I get some more time, my lord, because it can't be arranged within such a short.
Let the judge's brief be filed on 7th.
My lord, but
Then I can accommodate you.
Yes, sir.
May I have your lordship leave? Okay, mention. May I have your lordship leave to mention one matter, my lord? My lord, I am mentioning a matter to be listed as to be mentioned for correction of your lordship's order date itself.
Tomorrow.
7th.
Commercial Division, item number 2.
Yeah.
My lord, I'm for the plaintiff.
Who is the defendant?
Well, it is an undefended suit.
Yes.
The examination in chief is over, my lord. So now today is for final arguments, my lord.
Let me have the papers.
Yes.
Let me have the plaint first.
My lord will take the amended plaint because here there was
That installation of towers, telephone towers.
Yes. এটা করবো। Oh, please. iPad. My lord will take the amended plaint because
I can remember.
yes.
Only thing is to cancel the bank guarantee.
Yes, because
Since the entire contract has been cancelled, bank guarantee should be cancelled.
contract has been cancelled. The reason of that being when the tender was floated, there was
Extra
a
items
particular-
were added.
Yes, there was a particular item that was to be supplied. Now, when after that, when the advance purchase order was given, then we find that there were some additional items which were placed.
That's a kind of counter offer.
Yes, so basically they have altered the tender terms after my lord my bid was
You
accepted.
refused.
That I have naturally refused. Now, after my refusal, they had threatened invocation of bank guarantee. I have written to the bank not to honor any such request and also to cancel the bank guarantee. Now, the bank has not done that and they had also threatened the bank guarantee. So I had to file a suit. And it's a case of also not an unconditional bank guarantee, but a conditional bank guarantee, which was only
Have you
subject.
filed bank guarantee?
Yes, that has been exhibited.
Exhibits, let me see the exhibit file.
Just a minute.
Where is exhibit A?
My lord, the bank guarantees is exhibit B. I'm sorry, my lord. Bank guarantee exhibit B, my lord, is the tender, and bank guarantee is page 77. Exhibit C.
Where is exhibit B?
My lord, page
Exhibit B
57
का
of the
कौन सा है?
judge's brief of
Just a minute.
documents.
This is tender.
Yes. Exhibit C, my lord. That's a bank guarantee. And my lord, the tender is exhibit B. Page starts from page 3.
Now let me see what is the counter offer.
Yes, the counter offer.
This is the tender.
This is the tender and the relevant terms, my lord. I have to satisfy, my lord, your lordship in respect of the relevant terms of the tender. Lord kindly sees. Firstly, my lord, the tender, page 5 of the judge's brief. What is the tender for? Tender item 60 meters TTH. TTH stands for
Where you can say that there was a counter offer.
Yes, my lord. My lord will find
Exhibit.
yes. Exhibit after the submission of DD. Kindly come for the bill of materials. Page 25th July 26th of July 2007, page 62, exhibit F.
That is in judge's brief.
In the judge's brief, page 62. আমার কাছে আছে, আমার কাছে। In fact, this was given, if your lordship kindly takes exhibit F first, that is, exhibit E first, that is 25th July 2007, our letter, page 61. What happened was that there was a meeting of price negotiation committee. It is in course of that meeting, we were informed that there were some additional items which were required. So we had asked for the bill of materials by a letter of 25th July 2007, that is page 61, exhibit E. If I may place this letter with reference to your letter number so and so dated 12 July 2007, and as per the discussion held with the undersigned, we would like
Just
to.
a minute. Let me
Yes,
pick
I'm
it
sorry.
up. Exhibit F with reference to the subject letter.
Yeah, exhibit F, my lord, is 26 July 2007 letter, my lord. This is in response to our letter. My lord, if my lord takes my lord our letter first, which is 25th July 2007, page 61, exhibit E, then my lord, it will be clearer. July 2007, my lord, this is after the price negotiation committee meeting. This we write to them, we in reference to your letter number such and such dated 12 July 2007, and as per discussion held with the underside, we would like to inform you that we have not received the drawings of ladle and cable tray along with the tender documents, and we have not included the weight of the above item in our quotation. As per our BOM, that is bill of materials, the weight of tar is coming to 18.739 metric ton, and we have quoted our rate accordingly. We shall be grateful if you kindly send your BOM, bill of materials, as discussed in the meeting for further action in this regard. In response to this comes page 62, is when they send us their bill of materials along with the weight list. Page 62, my lord, is exhibit F. Page 64 and 6 onwards, 64 to 65 are the weight list as annexed or enclosed with the letter. Now from here, we find that they have added antenna holders to the towers that was required to be.
What is that?
My lord, now that, my lord, will find
Exhibit?
exhibit, my lord, page 63 is the exhibit, sorry, page 62 is the exhibit PD, that is exhibit F 26 July 2007, whereby they send the
new
bill of-
items.
and yes, and page 63 is the wait list. There, my lord, will find entry in page 64, entry 78, 79, 86, 87, and the next page, entry 117, Yeah.
78, 79.
78, 79, 86, 87.
Yes, tick marks are there.
Yes. And then also the next page, the tick marked items, my lord, but the ones which were additional weight. To this, my lord, now immediately when after we got this, we realized that the weight will be much more than what was anticipated in the tender. Now, if your, my lord, comes to page 66, that is our letter of 30th July 2007. So, my lord will see the timeline. 25th July, we write to them. They give us on 26th, and immediately after getting me on 30th July, we write back to them. That is exhibit, my lord, G, page 66.
Now, what was the response?
Now, there was, in fact, they didn't. I'll just place this letter, my lord, then I'll show what they have. So 30th July. Further to our letter dated 25th July 2007, we thank you for sending the BOM for tendered materials to us. Unfortunately,
This exhibit?
This is exhibit, my lord, G, page 66. Unfortunately, due to non-availability of the above-mentioned BOM along with the tender document, it was impossible to derive the accurate weight of the tower from the drawing provided in the tender document, which itself were very unclear. Additionally, the drawing for ladder cable tray were not provided with the tender itself, and also on page 31, description of the tender item clearly mentions without antenna holders. That is clearly mentioned in the tender. Whereas BOM has also included antenna mount weight. Under the above mentioned circumstances, we regret to state that our quoted rate of rupees 13,37,133 per tar cannot be held valid for the bill of materials that you have sent now. As we have mentioned earlier, the weight derived by us for this tar was 18.739 metric ton. And if you require us to supply the tar as per your BOM weight, that is 22.5 metric ton per tar, our quoted rate must be increased proportionately to accommodate for these increasing weight. We hope you will consider and favor us with your esteemed order. So now, they did not reply to this. What they did was to issue an advance purchase order in respect of the advance purchase order for supply as that is exhibit, my lord, H, page 67. So they altered the tender terms and issue an advance purchase order. Now, this advance purchase order read with the bill of materials that they have sent us is their counter offer. They issued a tender. That was an invitation to offer, my lord. We submitted our bid.
Yes, counter offer.
That's the counter offer. So, moment there is a counter offer, it is then thereafter an option is to us whether to accept the counter offer or not to accept the counter offer. Because the counter offer was based on supply on the at the same price, but with additional materials. And they had called for our unconditional acceptance of our counter offer. Yes.
What's your counter offer?
My offer was initially when I submitted my bid. So my bid was accepted. That was 12th of July 2007. I will show that document is there. Bid was
Which is
and
the
I
document?
yes.
That is exhibit.
That is my lord. I'll just give my lord kindly. Give me a moment. Yes. Exhibit D, page 60, 12th of July 2007, where I was called for the price negotiation committee meeting because I was accepted as a yes. I was called for the
price negotiation committee.
Yes, because after my bid was accepted, then only I was called for a price negotiation committee. My bid is not on record, but what is on record is my lord, the acceptance by calling me for the price negotiation committee meeting.
Then it is followed by?
And now this exhibit, this was followed by, my lord, the meeting that was held on that on 17 July 2007. And then in course of meeting, our specific case in paragraph 6 of the plaint is that when we were informed that there will be additional items which will be required to be supplied along with the towers, which will result in the weight of the tower being increased. Immediately that were thereafter, page 61, my lord, our letter of 25th July 2007, which is exhibit, which I've already placed, my lord, exhibit E, page 61, where we asked them for their bill of materials. That since we have found out in course of our meeting that there will be some additional items, which drawings were also not provided.
Where all these things took place?
This, my lord, these were between, my lord is inquiring about the dates.
Not dates, place.
This, my lord, had happened, our office was here, but the meeting took place at their office in Bangalore, but our office was within jurisdiction. So thereafter, my lord, we also submitted the bid from here, and then the communications we received at our office. The letters we have received at our office.
Leave was taken under letter
Yes,
section
yes,
12?
yes, yes. I'll just, my lord. Yes, yes. In fact, we were enjoying an interim order also.
All right, let me go through the papers.
My lord, will it be my lord's pleasure if I come with a short notes of argument with the...
We can do, but I will go through in my own way.
Very well, very well. Because I would, one judgment I would like to rely upon on the proposition that, two propositions basically, that a contract cannot be unilaterally terminated. Sorry, a contract cannot be or tender terms cannot be unilaterally altered. Once, my lord, the tender has already been floated and the bid has been accepted. And in the same judgment for the second proposition, that when a tender terms have been subsequently altered and the bidder is called upon to accept the bid with additional conditions, then the bidder is under no obligation to accept those additional conditions. And forfeiture of bank guarantee on the ground of non-acceptance is not permissible.
How long would you take?
Well, I'll take, I'll have to just show the documents and all the evidence and the judgment, maximum half an hour. I don't think this.
1 week?
Oh, my lord, for the notes. Yes, yes, 1 week. 1 week for the notes.
Hard in part. Adjourned to 27th February.
Grateful.
Item number 3, Commercial Division.
My lord, item number 3, I'm for the plaintiff. There's also an undefended suit, my lord. Here, my lord, all the formalities have been completed. This has been transferred from non-commercial to the commercial division. My lord, the affidavit. my lord, not exactly the
On
same
the
issue,
same
my lord,
transactions.
but a different transaction here. But only thing, my lord, here the witness action has not started. In fact, I was to file an affidavit of evidence of the witness. My lord, it could not be affirmed yet, my lord. There was some difficulty with the witness. Kindly
Same day?
same day, same day, same day.
Same
Or
day.
my lord, the next day, maybe on 28th, maybe, because if instead of, because the previous matter, my lord, has kept on 27th, my lord, this can be on 28th, my lord, if subject to my lord's convenience.
28th.
And my lord, the 20.
Adjourned to 28th February.
Yes, and my lord, the time to file affidavit of evidence, my lord, that may be recorded, be extended till 28th.
Time to file evidence on affidavit is extended till date.
Grateful, my lord, deeply obliged.
Witness action, item number 4, Counsel Division.
May it please your lordship.
Witness is present?
Well, for the plaintiff, my lord. My lord, this matter, my lord, witness, my witness is here, my lord. But prior to that, we have also made the compliance with regard to, my lord, the from transfer from, my lord, the non-commercial to commercial, my lord.
That is done.
Yes, my lord, affidavits are there. Only one affidavit is required to be affirmed, my lord, which we will be affirming in the day's time today, my lord.
Come tomorrow.
Okay.
First do it.
And my lord, only one thing, my lord. We have also, my lord, taking out an application, my lord. Now, my lord, that is for, my lord, summary judgment, my lord. The reason why, my lord, I'm saying it, in the written statement, the documents of us, when the plaintiff's documents have been admitted by the defendants, my lord. Even the cases, my lord, that is the reason, my lord, we have to take out. Now, my lord, they also have to make those affidavits ready because they also have a counter claim. So, my lord,
You come first, you are the plaintiff.
Yes, my lord, I have come first, my lord. I have, my lord, my documents ready now, my lord. And, my lord, regarding, my lord, we have to take inspection of the defendant's documents even, my lord.
But that's an instruction which I also have because there's been no admission and denial of documents. At least in our record, because it's a changed matter, my lord, we do not know if it is there in the
It
court
had
records,
happened long
otherwise-
time before, when we have to do it again, my lord, once.
If
We'll
has
finish it
happened,
shortly.
Yes, we'll finish it shortly, my lord.
Giving you 15 days time, finish it.
Grateful,
in the
come
meantime.
back. Yes, my lord.
Adjourn to 11th March.
The only difficulty is on the last day, it was, my lord, indicated that the adjournment is given as peremptory because they wanted
My
to start
witness
with
is
the
here.
witness
My witness is here.
The learned counsel for the plaintiff submitted that although the witness is present, an application is to be filed before witness action begins. On prayer of the learned counsel for the plaintiff, the suit is adjourned to 11th March.
Grateful,
deeply
come back, my lord. We'll do the other formalities in the meantime, my lord.
Regular list, item number 1 to 5.
My lord, this is appearing at my instance, my lord.
For corrections,
Correction. If my lord sees, my lord, I have done with the pencil.
My lord, it cannot be corrected. It is appealable. Already, order for substitution has been passed and amendment is being carried out by the department.
these are typographical errors in the order.
Leave is granted. It should be granted.
Yes.
Then, my lord, till then amendment shall not be
Shall
carried
not
out.
be
My
corrected. These
lord,
are typographical errors. These
Yes.
can be corrected.
only
No.
If I may indicate one point, my lord, since there was the note was not present, we had communicated by way of a letter to the department.
Yes.
Let me only make my submission. We had communicated to the department. It has transpired that the original plaint is not available with the department. There is some, it was communicated on 9th of February.
So far
There
today,
is-
it is fixed for correction only.
My
Confine
lord will
yourself
correct,
within
my lord
correction.
will only grant me leave to reconstruct the plaint. Nothing else. I'm
Let
not,
this be done first.
my lord.
Yes, what
the
is the
reason being,
problem?
my lord,
My submission is very much clear. On 5th, the application of the defendant number 7 was become redundant as per order of this court. And thereafter, one correction has been made as to the number of GA. Number of GA, this correction was made because GA number 34 is accordingly
Typographical errors cannot be allowed to prevail.
This is typographical, but he is saying that shall not be carried out.
my lord,
Yeah, that was the order.
that was
Because
ordered.
already order for amendment has been passed and the carrying out of the
My lord,
order
we
has
please
been
request,
given.
my lord, may I
Department
only,
has
Granted
already
till then,
started
conditional.
process.
my lord, I will not come in the way, but
Department
perhaps the only
already
request that
started
we are
process.
trying,
Order dated 8th February
my lord,
is corrected as follow. করে এটা দিয়ে দেবে।
my lord, only prayer that I'm seeking, my lord, may only indicate that the reconstruction of the
Come on the next date. adjourn to,
Shall not, he is totally
shall
making
appear in the
reverse.
list.
Because my lord, it will in effect stay the whole proceedings. I would only take steps for the amendment.
Because amendment.
Carry out your lordship.
Yes, yes.
Yes, this is to be done.
Order has been passed. That not the question of correction in respect of not or shall.
My lord,
Shall
what of
and
the-
shall
my
not.
lord, there
He
is
is
a complete-
What was the
making
dictation?
reversing the order.
Dictation, Michael.
He's
My lord,
trying
this
to
is
reversing
unfair.
the
My
order.
lord, my lord,
No. It is
the
fair.
order formula shall not.
What
be
was my dictation would be followed.
Yes, yes.
If shall was not on my dictation,
Yes.
it will not be inserted. দেখেন
Yes, yes.
But one thing, may I point-
ওটা তো টাইপোগ্রাফিক্যাল এরর, নট কথাটা কি
Till
ছিল?
then, amendment shall not be carried
No,
out.
no,
because it's fallen from a lordship on that
No,
day.
shall
My lord,
not
I
will
can
not.
show the YouTube recording.
No.
I can show
All,
the
all
YouTube
right,
recording.
come on the next date. I will check it.
may I
If it was there in my dictation, it will be there.
Yes, yes.
I will,
If I dictated,
Allowed.
yes.
Yes.
My lord,
if I dictated shall not be allowed, it will stand.
Yes.
If it is I dictated shall be allowed,
Yes.
that will stand.
Yes.
my lord,
This
with
much.
regard
That
to
I
the
will check.
34 which was allowed, I was only praying my lord will
But
direct
I
the
will
reconstruction.
Rely on
I am not,
February
I'm not getting in the my lord, it will only
Let this
expedite.
be done first. Come on the next date.
May I make?
My lord,
one
Adjourn to
point?
7th March.
Application has
can
been
be
hard
taken
and
without the-
Lordship will
Come on the
kindly
next
allow
date.
me to make
Yes,
one
yes.
simple
My lord, forgotten.
steps can be
Kindly
taken
allow me
without
to
the
make one
reconstruction.
submission.
It's a very unfortunate. There's a suit, partisan suit. Preliminary decree was passed way back in 1962. Parties are not fighting.
So it is there. Shall not be. That was my dictation.
Yes, shall
So
not
it will
be.
stand.
Shall not.
It
But
shall not be.
But in the contents of the
unfair.
order, it is clear that amendment has been allowed.
only consider the
What I dictated will be there. If you are aggrieved, file application for modification. In my dictation, not was there, so it will be put.
My lord, I am
That's all.
only praying,
For
my lord,
modification.
the reconstruction be directed, my lord. I will not take steps. I am only saying because it will take some time. It will only
That's the
expedite.
learned, Mr. Atul Dash, the learned counsel for the
My lord, I am for the applicant in GA 34.
applicant in GA 34 of
GA 34, Osman Sarif.
Yes.
34 of
My lord, 34 2022.
23.
23.
23.
23 submitted that plaint may be reconstructed for yourself.
No, my lord, for the entire records, it is
as
not
the
available
plaint
in the
is not
records.
available in the record. Who has the copy of plaint?
My lord, we all have copies, but those are photocopies. The original copy is not there.
The plaint may be given to the department. A report is called for from the department
Much obliged.
as to whether original plaint is available or not.
Much obliged, my lord. That would suffice.
Obliged, my lord.
The matter will appear in the list on
15th March, my lord, is already
15th March.
And my lord, I have a certified copy. If the report is so, I will submit, my lord.
Let it
Much
come.
obliged, my
Yes,
lord. Much obliged.
Parties
Much
should
obliged.
really come forward for taking out final decree, my lord. 62 preliminary decree
Steps have been taken.
Milord,
Next.
now the matter is over.
Item
Milord,
number
for a
6.
second, Milord, people nowadays forget that everything is being recorded.
Next.
Item number 6.
Milord, item number 6, Milord, I am appearing for the income tax.
এটা কিসের জন্য আছে দেখো তো?
Milord, for
Supplementary-
filing supplement, because Milord, the last occasion, Milord,
You are supposed to file affidavit.
yes, Milord, last occasion, Milord, we have prepared on one chart. Your Lordship was pleased to direct us to file a supplementary affidavit that the district one officer
yes,
is not
yes,
here.
yes.
Milord, you are filing supplementary affidavit, Milord.
দেখে একটু। Have you served copy? We must serve copy on the other side.
Because Milord, your Lordship was of the view that Milord, we are not on the party. Your Lordship was the view that first we file the supplementary affidavit and thereafter, if required, we'll serve the copy, Milord. Milord, your Lordship kindly see the Milord paragraph number 2.
Supplementary affidavit is filed on behalf of,
On Milord, the income tax department, Milord.
that is defendant number.
Milord, that is Milord defendant number. Milord, may I tell you, Lordship, Milord. Defendant number 5. Milord,
Defendant number 5.
5.
Let the same be kept in record. Copy may be served to the plaintiff.
And Milord,
The department is directed to furnish a further report.
Milord, only one thing, Milord, may I subject to Lordship correction.
আমি কোথায় অর্ডারটা দিয়েছিলাম কোথায়? জাজমেন্ট হয়েছিল তারপরে কারেকশনের একটা নোট দিয়েছিল না? ওকালতনামা নিয়ে। হ্যাঁ, ওকালতনামাটার জন্য তো রিপোর্টটা কোথায়? Department is directed to furnish a further report in continuation of its earlier report dated 18 January 2024. Let the matter appear in the list 7th March,
Only one thing, Milord,
4th March.
may I subject to obfuscation, may I enlighten that, Milord, Milord, to kindly see this letter, because, Milord, I believe the dispute in the suit, Milord, that can be, Milord, dissolved, and, Milord, plaintiff may take back the, Milord, copy of their articles. That's why, Milord, they are not appearing before your lordship.
Six two.
Yes, Milord, because, Milord, they are not appearing because the decree was passed, Bhokaratnama was not there. Your lordship was directed us to file the Bhokaratnama. Now the department, they have, Milord, made party in the, Milord, plaint, that is not there. Your lordship directed us to file Bhokaratnama. We came and we said that, Milord, the
Subsequently problem cropped up because that department was not in existence.
existed,
So
Milord.
the
Your lordship,
supplementary affidavit will be
yes,
filed.
Milord, we say that supplementary affidavit by of something down the department is such and such. Milord, if they, Milord, further move to, Milord, proceed, Milord, they have to correct the, Milord, the plaint.
Yes, the department will take steps and report.
Milord.
Further report.
For the defend number 1.
Further report on কবে বললাম? All right.
Milord, deeply obliged.
Item number 7.
May it please your lordship.
Correction.
I appear for the petitioner.
What corrections?
It's appearing on my behest because, as I had indicated, my lord, we were under some confusion. We ourselves were under some confusion as to whether the main application, that is AORC 2 of 2007, stands dismissed.
Use microphone.
Yes. Whether the AORC 2 of 2007 itself stands dismissed for default or not. Now, বের করে রাখ এই motionটা। এই জুনের অর্ডারটা, এই জুনের অর্ডারটা। সাহেবের কাছে তো আগে
Let me check it.
No,
Let me
my
go
lord,
through the order.
may I, my lord, apprise? In the meantime, it's my duty to you, my lord. As far as we could ascertain, the order dated June 2, 2018, I believe a copy whereof was handed up to my lord's officers.
June 2.
June 2, 2018, 4th June 2018 order on which we are really relying upon. It appears, my lord, by that order, not the AORC. It's I must come clean, my lord. It is a GA in that AORC which was dismissed for default. AORC, as far as we could ascertain, AORC.
Where is that order? Order টা বার করো।
Order দিয়েছে আপনাদের? order দিয়ে দিন।
My lord, may I hand over? I have it. Your lordship, I'm handing over
You do
4th
one thing.
June and
Get a copy
thereafter
from
the
the net.
13th June. Now, my lord, on
Get
the
a copy
last
from the net.
occasion, I had made a submission before your lordship. That, my lord, in the event the AORC would have been dismissed for default as contended by my learned friend, the master summons could not have been proceeded with.
Any event, my lord.
Any event.
Yes.
Now, my lord, the 4th June order and the subsequent 13th June order would say that the GA, my lord,
Yes, 2 of 2000.
Order দুটো বার।
3984 of 2007 stood dismissed for default, and the application
Yes.
for restoration was GA 1060 of 2019, that is pending. So, my lord, the AORC itself
Let me
is,
go
my
through
lord.
the record first.
Yes.
Come on the next
Now,
page.
only another thing, because now I think we are on the same page as far as that part is concerned. It was our mistake. By the order that my lord has passed, lordship has been pleased to reject my learned friend's prayer, my lord, for setting aside the abatement of suit as against the respondent numbers 2 and 6. That is my client. Their legal heirs. Only indulgence I was seeking. Would it be my lord's pleasure, because so that there is no further confusion in the future for future reference,
to indicate that prayers, at least prayer B, relief B as sought in the notice of motion stands rejected. Only that much.
Let me go through the
Yes,
record.
yes, yes. Only that much. Nothing else.
I have to also check this
Yes, yes,
dictation.
yes. A copy of order has been handed over, and that part Lordship would kindly consider. So that
Your lordship has already passed an order, my lord. My learned friend on
Let
an
me see
oral
whether there is
submission,
inconsistency, anything is incorrect.
my lord.
only that
Come
much.
on, come on, first match.
Yes.
First
Great,
match.
great, grateful.
Oblige me.
এটা একটু চেম্বারে নিয়ে আসবে তো অপশন নেই শর্ট লিস্টেশন দিয়েছি আমি আজকে চেক করতে পারবো কালকে বা পরশু তো
একটা we will hand up a copy of the bunch of the orders to my lord.
Better,
Lordship in the
better.
course of the day. I think that's better. And my lord, Lordship
problem is
kindly
that
consider that.
lot of cases that there where the old orders are not available.
Even we cannot most of the.
My lord, if my learned friend can also, my lord, hand over a copy to me, my lord, I will also reconcile. That was made, a request was made to my learned
Lordship will kindly
learned friend's
consider
advocate
that
on
part,
record.
whether that can be
I have to
nothing
check it
else.
then.
No, nothing, no change or anything.
আমি কি formal চিঠি লিখবো আবার? চিঠি was not accepted
Item number
in your office.
8 and 11.
No.
11 না 12
No, 9 to
8 আর 12 অন্যটা কত 12 অন্যটাও তো appear করছে
8 will be with 11.
Yes, my lord, because 11 is my application under section 340. I am the defendant number 3 in a partition suit. My item 8, my lord, is an application for substitution, my lord, of the legal heirs of the defendant number 5. My
That should be allowed first.
Yes.
Considered, not allowed, I should say considered.
My lord, but the defendant number 5, my lord, died on 27th of December 2023.
Where have you stated this?
My lord, that I have stated in paragraph 5, my lord,
Yes.
page 4 of my affidavit.
Sujata Shuchanti
Sucha. My lord, that's the defendant number 5, my lord.
expired on 27 December.
December 23, my lord. But the legal heirs have been set out, and I have also made the proposed amendment. Lordship will find that at page 8, where the proposed amendment in reading has been made on the plaint, my lord.
When have you filed it? Any explanation for delay?
My lord, it is within time, my lord. 90 days within time.
GA, have you served copy? Have you got
Yes,
copy?
yes, your lord. Yes, your lord.
GA 15 of 2024 is filed with a prayer for prayer for recording death of defendant number 5 and bringing in record her legal heirs and successors. Full stop. Copy served. The application is filed in time. There is no objection on the part of the learned counsel for
Respondent number 4.
respond. Who is plaintiff?
But plaintiff number 4 is
Your lordship,
Oh, you are
actually-
plaintiff.
He's plaintiff.
Problem is that your lordship, my client, who is actually is the plaintiff in the suit, is has not given any power in respect of the plaint to me. So I cannot be called as a advocate appearing before the plaintiff. I am only appearing on
Then who is representing the
party
plaintiff?
application.
Who is representing the plaintiff?
He's been appearing all
No,
along.
actually, as per my knowledge, your lordship, T. Banerjee and Company is the plaintiff's advocate on record since 1977.
My
How
lord,
this
friend
can
had appeared in the past. I don't know on what authority he's been appearing there.
Only on Parjari application, your lordship. Only on the Parjari application.
in respect of one application.
There cannot be any segregation of lawyers. One lawyer for the suit, one lawyer for one interlocutor.
What your lordship?
Substitution.
Okay, এটা করে দাও,
What about your lordship?
allow করে দাও। Objection লেখার দরকার নেই। কি বললাম? Prayer A,
আমি তো এখানে বলেছিলাম যে তুমি থাকবে, মানে আপনি থাকবেন ম্যাটারের সঙ্গে, কারণ
and B of the master summon be allowed. Semicolon. Plaintiff may be name of the legal heirs and successors
Read correct করতে হবে না,
of the defendant number 5 may be inserted in the plaint.
your lordship, only one thing, your lordship, there is no direction for amendment in the plaint, your lordship, in their master summon.
Plaint may be amended accordingly.
না, prayer নেই।
re-verified, amended accordingly, comma, re-verified, and re-verified, comma, and re-verified. Department is directed to do the needful in this regard. The department shall also submit a furnish a report on carrying out of the proposed amendment. Let me call for a report from department whether the amendments are carried out or not. In that sequence, they will file.
Very well.
If the none appears for the plaintiff, they will submit a report, obviously.
Yes.
Then things will come into light.
That's right. Well, that item number 11 is a connected application, which is my application for perjury. Should we come back after the department
Yes.
does the needful? Well, can you give a date then for that matter? Well,
GF 15 of 24 stands disposed of. Let the matter appear in the list on 15th March for hearing on GF 4 of 98.
I'm grateful, my lord.
Item number 9.
We have finished hearing.
My lord,
Wait,
they
wait,
have completed their submissions. I
I
have
just
more or less placed.
one moment. I just, my lord, needed to hand up these judgments, which copies I had already given. I've indicated the paragraphs and the contention. That is 18th judgment. Atcon, Excel, RP judgment.
Have you placed it? I don't think
No, none of the judgments we have. The judge said that you just mark the paragraphs and hand it over.
Yes, because I do not know.
But my learned friend wants me to place these
No,
judgments.
I do not want him to
I have
place because I do not
indicated the
know, my lord, what is there. Because I do not think he has the
Let me see the
two judgments, my lord, even I am relying on. And insofar as
My lord, are on section 22 of the Specific Relief Act, which gives me, my lord, an opportunity to ask for amendment and insert recovery of possession as a relief in a suit for specific performance.
There is another judgment
One-
which will be more helpful to
And
you.
one
me have it.
judgment, my lord, is this one, that is, my lord, on the general principles of amendment with respect to plaint. This is the latest judgment passed by the Honorable Supreme Court. I am relying only on paragraph 36, which encompasses.
we have not been served with a copy of this judgment.
I have a
In
copy.
fact,
I'm
he's
sending.
just now citing it. It has
No, no,
not
I
been
wanted
cited
to
earlier,
refer.
nor
Your
has it been
wants me
made
to
over
only
to
hand
me
it
as of now. But be that as it may, if a copy may be served, then I'll try and distinguish it right now.
2023 SSC on.
Give a copy. Atcon and Excel will come.
And my lord, just
Another one
more.
is there.
Another one, my lord, is yes,
I'm relying on one more, my lord.
Ganesh Prasad. Yes. Paragraph 36.
Oh, thank you. আমাদের তো কি গণেশ প্রসাদ?
Come on Friday.
My lord,
My learned friend will be citing some judgments. That is what he said.
Come on Friday then.
my lord, all I need is perhaps 10 minutes of your lordship's time. I'll demonstrate because this matter your lordship
I've
knows
heard
has
extensively.
been and
It is dragged.
it is being dragged. My lord, I wouldn't make any comment insofar as the conduct of the plaintiff is concerned. I'll only place, my lord, the plaint and the few judgments. 3 of them, which
So come on Friday.
very good.
Heard in part adjourned to 23rd February.
Obliged.
Grateful.
Item number 10.
Yes, what happened?
I beg to appear on behalf of the defendants.
Well, in this matter, on the last occasion, this is just
It was issued.
well, it is to be ascertained, my lord. On the last occasion, my lord, my humble submission before your lordship is on 5th of February, the matter was taken up by your lordship to clarify the order of 23rd of November 2023, whereby your lordship was pleased to appoint the partition commissioner for execution of the partition work. Now, on 5th of February, my lord, what happened is your lordship was pleased to pass 5 independent directions in the matter. One was with regard to issuance of writ, which your lordship was pleased to. Secondly, my lord, the receiver was being directed to come up with a report in connection with the fund that he was lying with him, because expenditure of the commission work is to be paid by him. That was the direction of your lordship in the order of 23rd of November. Thirdly, my lord, I personally, my lord,
Let me go through the report first.
Okay.
I may need to have pass
Yes.
part that direction.
Yes, your lordship.
Writs were issued.
It's not issued, but before regarding the issue of it, I shall make submission. I am not feeling well. That is why I asked him to say before your lordship.
No, the first thing, the report is there. The first thing we have to do is to reconstruct the record. That is the prayer here.
Yes, your lordship.
Cost papers are not available.
Because before this read, my lord, certain things has been there. Because in the meantime, many parties died and they are substituted. Their share was not determined. The partition decree, my lord, unless final decree is passed, nobody, if the final decree is required to be amended. And share should be determined first. Otherwise, it will be infractuous.
Let the record be available first.
On the
Record
last
reconstructed.
occasion, your lordship was pleased to direct the registrarman original site to place before your lordship the preliminary decree. If that had been drawn, my lord,
Not available. That's the report. Not available.
Not available.
So record is to be reconstructed.
That is unfortunate because yes.
So
The report of the learned register in charge original site is placed original site dated 13 February 2024 indicates that cause papers are not lying with the department.
Dharana.
In view of that, record is to be reconstructed. Have you get copies? Got copies?
No, my lord.
We have not been provided. We communicated your lordship's last order before the register office.
We did not receive, my lord. We searched. We also prayed for getting the copy. We did not get it.
We conducted an inspection of.
I have a doubt in the mind whether report was prepared or not, my lord. That is why I last question. I made a submission regarding my.
No, unless the record is reconstructed, we cannot go ahead.
My lord,
record is to be reconstructed.
It was passed in 1963.
Yes, that is there in the report. That is there.
In the meantime, Lord, that decree cannot continue in this way unless it is amended.
Let the preliminary decree be available in the record.
Yes.
No,
that is the first thing.
No,
then that can be reconsidered.
Yes.
The question of opening up will come up then. Even for adjudication, for passing final decree, for whatever that might be, unless there is a preliminary. Got a copy?
That is mandatory, your lordship.
We don't have.
We have conducted a thorough inspection, my lord. As per your lordship's order of June 2023, parties were given the liberty to inspect the records. We have conducted on a basis, my lord, we have conducted a thorough search on the records that were lying before the decree section as well as the original records. Well, nowhere we could find, but every application falling pursuant to the preliminary decree that was being drawn in 63, my lord, speaks of that preliminary decree has been drawn. That is the reason why.
We have to see the preliminary decree.
Yes, there has to be a physical existence of that document.
If your lordship recalls, I think the possibility why this is not available is because it has not been drawn up and completed by the plaintiff. If your lordship recalls, I had mentioned this on the last occasion. Therefore, it needs to be drawn up and completed, and only then would it be available in records. But so much time.
It is not only preliminary decree. The cost papers are not available.
Cost papers, my lord, I think.
That is the report.
Cost papers, more or less, I think should be available. Only the preliminary decree is probably not available.
Cost papers are not lying with the department.
No, they are because they are here, my lord. The cost papers are here. They're all here, my
lord. Preliminary decree is not there.
Only the preliminary decree is not available from anybody. Neither does anybody have a copy.
We could also find it in the decree section.
Preliminary decree
conducted a search. Well, subject to correction, the only reason why it could not be available is drawn up and completion. That's the only reason I'm apprehending. And so much time has passed.
No, decree was drawn up. Decree was drawn up.
Preliminary decree was drawn up.
Yes, on 15/6/70.
On 15/6?
70.
70.
70.
Then I think, my lord, then it should be available. Then it should be available with the records.
Check kore na.
I have carried it out, my lord. My learned friends have also carried it out.
ড্র করা হয়েছে
decree was drawn up.
Decree was drawn up. You go through it.
Sir, this maybe.
Please.
Submitted a note for decree was passed on Article Keshwati by one PC Molly. Decree Department B
There is possibly a typographical error. It was 1963. It should be 1973. Requisition was made.
Preliminary decree, my lord, what is the date of the decree?
By the Honorable Judge of the same time was delivered to the Congress.
No, it has.
What is the decree?
77.
What is the original decree? What is the it was drawn up?
Date of preliminary decree.
That should be in the records, the decree. The decree, my lord, according
Copy
to
of the
this
decree.
order, the decree was drawn up. But there should be existence of the decree in the record.
Decree should be in the record.
There, my lord. By respectful
63.
submission before your lordship.
Decree টা নেই ওখানে রেকর্ডে?
No, your lordship. Your lordship may call for a copy of the decree, my lord, from the department. Because then
Have you gone through?
they are only indicating the date of drawing of the decree.
Yes, my lord, the departmental note says that the decree.
Decree was drawn up.
Requisition was made by B.N. Basu and Company.
Then decree was drawn up.
Decree was also drawn up on 15/6/1970, as it's fallen from your lordship. My lord. The cost papers, of course, are here, my lord, but I'm surprised
But that decree is not here.
that decree is not here. That we've all
Okay,
carried
dekho
out
to.
our search.
Copy of the decree.
Because once that is available, your lordship is right. It will actually throw a lot of light on everything.
Yes. Because if the preliminary decree shares are to be redetermined,
Absolutely.
that is absolutely on the basis of that preliminary decree.
Correct. Absolutely.
Unless that is there.
In fact, as your lordship has rightly said, that would be the starting point for all things to come.
Yes. The report of the learned registrar in charge of original site, dated 13 February 2024, is placed before this court. Full stop. It appears that preliminary decree was drawn up and complete on 15/6/1970. Full stop. It was delivered from the concerned department. The department is to search out and place the preliminary decree before this court on or before the returnable date.
Your lordship.
My lord, may I suggest something?
On the last occasion, your lordship trying to dispose the case expeditiously, but for our wrong action, your lordship will not be able to do it. It is my submission, because our commissioner receiver is not fair before your lordship. I must say.
But your lordship, on the last occasion.
Anyway, let the preliminary decree come. We will decide the issue.
One issue.
Occasion, your lordship.
Accident.
Wrong order was obtained
Accident.
regarding the disposal of the money.
আমি বলে
Commissioners, my lord, Mr. Bhattacharya's remuneration is to be fixed later on, your lordship.
Let the decree come first.
Well,
And-
one thing has happened in the meantime. Just if I may just very, very in short, my lord, if I may just narrate one thing. On the last, pursuant to the order being passed by your lordship on 5th of February, your lordship has categorically recorded in the order the submission, incorrect submission, my lord. That is an incorrect submission, I would say rather, because that is contrary to the records that are lying before this court. My lord, the custody of the funds that is lying with the receiver right now is the earnest money deposited by the bidders in connection with the Farsi hookah auction matter, my lord, way back for 2016. The sale proceeds with regard to the coin, East India Company coins that were lying before this court, my lord, to the extent of 8.8 lakhs, were being disbursed in 2018 pursuant to an order of the court, my lord, by Justice Somen Sen, as his lordship then was before that court, my lord. Pursuant to that order, that amount of 8,80,000 that were the sale proceeds of the coins were being distributed amongst the heirs, my lord, as per their shares. So nothing that with regard to the coin was lying with this person. And secondly, my lord, what wrong impression is being given to the court is that the money that is lying with him now is nothing but the earnest money of the private bidders, my lord, which is who participated for the auction of the hookah. But that is those orders are there. So, my lord, those orders have to be
do
placed
one
on
thing.
record.
You submit, furnish a report on statement of account. Give a statement of account.
Detailed, my lord, detailed. No, my lord, they are not providing a detailed thing, my lord. But there are speaking
Report is
orders
called
of
for.
this court. And my lord, on the basis
Just
of
a minute.
Yes.
Don't go on arguing.
No, your lordship.
A report is called for in the form of statement of account from the learned partition commissioner.
Yes.
Writ is not issued.
Well, receiver.
Receiver. Writ is not issued.
Not to our knowledge, my lord. It is their application. They should be
Well,
aware.
your lordship, on the last occasion, the very first line, my lord, your lordship was pleased to direct the department to issue it. I do not know, my lord, whether that has been taken care of.
Stopped.
Let the matter appear in the list on 5th March.
And whether the receiver had disbursed some amount, my lord, to
Statement of account. That is why statement of
but in the
account.
meantime, my lord, the receiver had disbursed some amount, my lord. That is the
Let the
problem.
statement of account come, then I will pass order.
Yes, your lordship.
Another important matter, my lord. I
Going on, sir.
may before your lordship drop a quantum proceeding summary of your lordship because they dispose some property and we received those party, my lord, 15 crores by selling the property.
I am sorry, my lord. That is, I am
Let
objecting.
let the statement of
This is
account
not
come.
the subject matter of this suit.
Lordship.
This is not the subject matter of the suit. I'm sorry.
My lord, if my landed friend starts saying all these things,
Then
I can't restrain myself from submitting.
No, I will make
I-
submissions on this. My lord, this matter
This part, let the statement of account come, then we'll check.
These are all irrelevant facts.
wrong
These
submissions
all
are being made.
irrelevant facts.
Come with the statement of accounts, next day I will check it.
Wrong submission. The matter is fixed in the writ court tomorrow. What submission is he making? He's appearing in that writ court matter.
And as per
Heat court, it is a separate.
That is the exact matter.
Acquisition.
Then if it is so, why shall I issue suo motu contempt?
Sumoto contempt because what are
Without the leave of the court.
subsidies of the matter.
No, I'm sorry, my lord.
Then why don't you
No.
making an application?
My lord, the last decision this year, the Supreme Court said, if any comes to the knowledge of the court, any party is.
All right, you have submitted that things are done.
There should not be any lenient.
Very
because of
good,
this matter.
very good. You have submitted that things are done, violating the order of the court.
Yes, my lord.
Verbally,
No, my lord, which order?
please,
If your lordship do it,
verbally.
may be given liberty to file application.
That's up to you.
Yes.
Verbally, now he is contradicting.
I'm contradicting.
Court cannot obviously follow with that.
There is no order.
If this thing have come,
Contiguous contact has been drawn to the brought to
Hold
the
on.
notice.
why, if there is something happened like that,
Yeah.
you must have to file documents.
yes.
Yes, we have
We
a
will.
document.
Then do that.
My lord,
Let that application come.
my lord, the important thing, again, I'm,
That document.
Let that application come.
my lord, I'm
For future thing, I'll not hear any
I'm
argument.
just making a contradiction to what he's saying. He's saying there is a,
This court is not taking care of that submission.
no, he's saying,
Once he will file an application, he will be given
very
opportunity.
well, let him file which order against it has been contempt. Let
Yes,
him file.
that must be no.
Yes, my lord.
Knowing fully aware, they have taken out this application. On the basis of that application, joint commissioners have been appointed and they have already started taking action. Now their strategy is they are neither allowing, they are neither cooperating, neither allowing all of us.
Let this application come.
No, without
Then we
ascertaining,
will consider.
without ascertaining, my lord, whether there is a preliminary decree.
No, where is his
How could this
application?
begin with this work, my lord?
Then why have you come with this? If that is your knowledge, that is your understanding, then why have you mentioned this?
Why are you
My lord,
mentioning?
we have taken out
We have
applications.
filing application.
We have
We are
If that application cannot be heard without preliminary decree, then why did not you wait for preliminary decree? Why did you mention today
My
itself?
lord, that is the reason why, my lord, we took that application, my lord, before your lordship, and at the time of disposal, your lordship was pleased to direct the department only. That was in connection with the application.
Today you submit that without preliminary decree, that application cannot be heard. Just now you said,
You just said it.
Yes, but we were proceeding on the basis that there was a preliminary decree, because every document.
then let
Which is before this
preliminary
court.
decree come.
Yes, yes,
Unless this preliminary
I'm
decree
grateful.
come, according to you, this application cannot be heard.
absolutely.
Yes,
Then babbling is not necessary.
yes,
Unnecessary talk is not necessary. Be precise. Come on the next date.
yes, your lordship.
I will mention this.
And your lordship, the
tomorrow in
plaintiff is not appearing in.
That's all. Next matter.
My lord, matter is Item number 12. 5th March.
5th March.
5th March.
Well, liberty may be even to clarify the file. Inspect the file.
Let the preliminary decree come.
My lord, may I submit one minute? As direction fallen from your lordship, we the joint commissioners have already acted upon and we have already inspected the premises. Although we have given prior notice to my learned friends, they did not.
That's
turn
up to you.
My lord, may we proceed with the.
There cannot be verbal direction like this.
Yes.
You come with a report, things are this. If you solicit any instruction from this court, file in a form of
No,
application.
no, my lord, I think my learned friend did not been able to make himself clear.
But from the earnest money, the receiver already paid 1 lakh rupees to
Your
advocates,
lordship
my
had-
lord. How that can
On a clarification that I had sought from your lordship had told
My
us that
lord,
you please go
receiver-
ahead with the inspection work. That's why we were continuing with that.
Yes,
And we can continue with that same work also.
absolutely. Who
That's-
part you?
That's all we are asking for. That's all.
That's why I passed direction for issue of writ.
Correct. Correct. That's right. Exactly so. I'm obliged, my lord.
If someone has any problem, let them come with an application.
Absolutely. Come.
My lord, kindly hear me, my lord. Because your lordship last occasion directed, the payment maybe 3 persons has been appointed from advocates. I respectfully submit before your lordship, those advocates are being paid by the clients. Why they should take the remuneration from the court, my lord? That is also not correct, my lord. Second thing, my lord, let me
Next,
submit, my
on the
lord.
next day, let
And
this,
in the meantime, my
on the
lord,
next day, have you filed any application for
kindly hear me.
modification?
In the meantime, my lord, receiver already issued checks of 1 lakh to advocates.
Yes,
Why, my
pursuant to your
lord,
lordship's
without
orders.
submission, Commissioner did not
All
work.
right, you said that order is not correct.
Stop, my lord.
The order is not correct.
Ask for a modification.
Then why did not you file an application for modification?
No modification because we have come today. We have come, my lord.
Then file an application for modification.
Requested them.
He will not
to allocate the money.
He won't participate in the
Next
inspection.
matter,
And he will continue.
if you have any grievance, file application.
Yes.
Next matter.
Give me.
Item number 12. And I will take this care of it tomorrow in the writ court. Come.
We should be fair in all
Yes. Everybody should be fair, not only me. Item number 12.
Lord, 12, my lord, was
12.
hearing me, my lord.
This is your 397 application, 397 related issues.
Yes. No, the other side's 397 application, my lord.
Where have you mentioned this?
Correctly, my lord. Put it, my lord. Other side, my lord, is the plaintiff. I'm the defendant. So other side's 397 application, filed, my lord, before the High Court. Now, my lord, with section 430, the jurisdiction, my lord, is gone. That is, my lord,
Where it is in the pleading?
my lord, in the application itself.
In which
In
paragraph?
GA9, my lord.
GA9, which paragraph? All right,
24, yes. My lord, in 22 onwards, my lord, will find.
22 onwards. 24, you said barred by jurisdiction is barred.
Yes. Or rather, my lord, in fact, 19 onwards, my lord, it starts. And we say, my lord, it's the National Company Law Tribunal.
Powers vested in 20 also. 19 onwards.
19 onwards. My lord, recall, my lord, the issue was, and my lord had asked me a question, and quite naturally, my lord correctly asked me a question. My lord, I'll just take 2 minutes just to come back, my lord, where we were. My lord, I had shown from the plaint, particularly, my lord, paragraphs 26 and paragraph 30. And 30 itself, my lord, says operation and mismanagement. My lord, that's at
Just
page
a minute.
41 and page 46 of the plaint.
Page 40.
My lord, 41 of this application, my lord, will find. This is what I had shown.
29, 30.
Paragraph 26, my lord, will find. Page 41. This, my lord, I showed all relates to issues under the Companies Act. And I had shown, my lord, all the sections also, which relate to that. And then kindly come to page 46, paragraph 30.
Mismanagement and operation.
Yes. So they themselves say guilty of acts of mismanagement operation, which is summarized here in below. And in the prayer, my lord, will find at page 52, a scheme be framed for management and administration of the Definition 1 company.
Prayer A.
Prayer A. And in the Companies Act, my lord, we had also shown section 430.
No, possibly 1956 Act will apply because at the time of institution.
Well, 1956 Act, my lord, stands repealed now.
Yes,
It's
but at the
20
time of institution of the suit, that was prevailing.
That was prevailing. But, my lord, now, my lord, 2013 Act will apply. And section 430, my lord, I'll just show, my lord, kindly takes 430. And I'll show, my lord, the provision of law, my lord, on this. Lordship Act of Companies Act.
And this is exactly, my lord, where we stopped on the last occasion. My lord, while looking at section 430, my lord had asked me a question, which is, my lord, what I have to answer. No civil court. No civil court shall have jurisdiction to entertain any suit or proceeding. Any suit or proceeding in respect of any matter which the tribunal or the appellate tribunal is empowered to determine by or under this act or any other law for the timing in force, and no injunction shall be granted by any court or other authority in respect of any action taken.
Power of the tribunal.
Or taken any power conferred by the tribunal. Correct. Now, my lord, the question which correctly, my lord, fell from court is entertain means what? Does it mean that future suits or whether it will apply to pending suits as well? Now, my lord, I'll show that, my lord. The case law, my lord, is very clear on that. Entertain, my lord, means the ability of the court
to hear.
Yes. To hear the matter when, my lord, takes up.
And to consider. Anyway.
It is not a question of, my lord, initial
powers of the tribunal.
Sorry, my lord.
Powers of the tribunal.
Yes, my lord, that is 241, 242. Powers of tribunal, my lord, fine, my lord. 241, kindly see, my lord, the heading itself. Prevention of operation and mismanagement. 241, any member of a company who complains. 241(1). Any member of a company who complains that affairs of the company have been or are being conducted in a manner prejudicial to public interest or in a manner prejudicial or oppressive to him.
According to you, this is the where the tribunal gets jurisdiction.
Yes. And they clearly say, the reliefs claimed for are in respect of affairs of the company, management and administration.
Then powers of the tribunal, 242.
242, absolutely.
Regulation of conduct of the affairs of the company.
I'm grateful. I'm grateful.
So according to you, in view of 241, 242,
yes,
civil court has no jurisdiction.
So 241, 242, I'm saying the subject matter of the suit is the subject matter or will be the subject matter of 241, 242 application. Clearly, operation 242 says, 242 says that regulation of the conduct of affairs of the company. And read with 430 now, which has come in, the civil court will cease to have jurisdiction. It will have to go to the National Company Law Tribunal, which is a specialized body, which has been constituted for the purpose of dealing with such kind of matters.
All right.
That is why the suit is barred. I want to rely on certain judgments.
Yes.
2019 SSC. 2019-18 SSC. 2019-18 SSC. Lord, kindly look at.
Do one thing, come with the notes of short notes of argument.
But we have prepared one.
Annex all
preliminary written notes, we have prepared.
Annex all these judgments and file it on the next date.
We can do that. May I just show just one judgment, just for because to show entertain what entertain means. Just two judgments, just give me 5 minutes. I just show. First down, 1971. Yes. Kindly look at 1971. 3 SCC 124. This is straight away, what had fallen from my lord, and I want to answer that issue.
Adjudicate upon.
Yes, my lord, kindly come to my lord, paragraphs 2, 3, and 4. একটা copy যদি থাকে তাহলে 71 3 SCC. My lord, kindly come to paragraph 2. The amended proviso with which we are concerned in this appeal reads thus: provide no application to settle shall be entertained.
That is in para 4.
Para 2, 3, yes, then the law is in para 4. Before the High Court.
Contention of the appellant.
It is the contention of the appellant that the expression entertained found in the proviso refers to the initiation of the proceedings and not to the stage when the court takes up the application for consideration. This contention was rejected by the High Court, relying on the decision of that court in Kundalal. Same view had been taken by the said High Court in Dhumchand and Haji Rahim, and again in Mahavir Singh, Gauri Shankar. 60. These decisions have interpreted the expression entertain as meaning adjudicate upon or proceed to consider on merits. This view of the High Court has been accepted as correct by this court in Lakshminaran Engineering versus Assistant Commissioner. We are bound by the decision, such we are unable to accept the contention of the appellant. Clause B of the proviso did not apply to the present. Well, I'm saying entertain doesn't mean the initiation of the proceeding, but entertain means when the court is in a position, when the court takes up the suit for hearing, court will see, no, sorry, section 430 as a bar.
Next.
The other one is Kemka. Eta konta? No, no, Kemka. Just look at 2019. 18 SCC. (2019) 18 SCC 569. This related to on the erstwhile section of 100 and 111 E. 2019 18 Supreme Court cases 569. Kindly come to paragraph 4. The learned counsel for the appellant has drawn our attention to the view expressed in Ammonia Supplies Corporation, canvassed the proposition that while examining the scope of 155, precursor to section 111, a view was taken that the power was fairly wide, but in case of serious dispute as to title, the matter could not be.
Para 6.
Yes. Then paragraph 5, 430 set out, then it is not in dispute that there was a dispute to arise today. Civil suit remedy would be completely barred and the powers vested in National Company Law Tribunal in section 59. We are conscious of the fact in present case, cause of action has arisen at a stage prior to this enactment. However, we are of the view that relegating the party civils now would not be the appropriate remedy, especially considering the manner in 430 of the Act is widely worded. We are thus of the opinion that in view of the subsequent developments, appropriate course of action would be to relegate the appellants to remedy before NCLT under the Companies Act. Lapse of time, we permit the appellants to file a fresh matter. Well, there are other cases that I'll show on the next. We have prepared the notes, preliminary notes. If they are also wanting to,
I must hear them first.
So I
can say.
Sorry,
have you anything to argue?
I have to just show these cases which talk about on the question that if the jurisdiction is ousted. First, the entertain is very important because right. 430 is very clear. And then if jurisdiction is ousted, then quite naturally the civil court will not
be rejected.
Yes.
And that's not barred by the suit.
Sorry,
barred by law.
Barred by law because of 430. Because
it's the operation of 430.
Correct.
Now your next point is relying on this judgment. You said that even though suit was instituted at the pre-amendment or pre-modification stage, yes, that will apply.
That will apply because also will find that the section the Companies Act 56 deleted. Malad 56 Act has been now repealed and because it is not a question now anymore of the 1956 Act because this was also not filed under the 1956 Act. So what we are concerned with, this is a civil suit. This is a civil suit which now by reason of operation of section 430, which is very widely worded, that gets barred. They're just three. I can just quickly show the judgments or just give me 2019 SCC online Calcutta. This was no Bhaskar Gupta. I don't have a copy. I have a copy. This is I don't know. It's a Calcutta Club. Paragraphs 20 728 এটা মানুপত্র থেকে দিয়েছে একটা কপি তাও দিয়ে দাও kindly look at 27, 28, 29.
Paragraph 27.
27 onwards.
Before parting.
No, I'm just showing the challenges which was there in that suit. I'm just showing now the subject matter, if it comes under the scope of the Companies Act, then 430 will bar it. So though this suit was instituted subsequently, but I'm showing how the affairs with regard to that extraordinary meeting was challenged, and that was considered to be within the scope of the section 241, 242. Thank you. 29 SCC online Calcutta. No, copy though. Okay. বলে কপি আছে না 2019
একটু দাও Yes.
2019 SCC online Calcutta 6663.
Paragraph.
Paragraph 67 and 74 to 76. Just kindly make a note of that and that. Also lists out what could be outside, but here then it was held. Registration of shares and operation mismanagement.
67, then paragraph.
67, then paragraphs 74, 75 and 76.
All right.
1903 SCC contact. And I'm just giving this judgment. It's on the same proposition. 2019 again Allahabad though. SCC online Allahabad 4600. Nirbhay Kapoor. 4600.
Paragraph.
Paragraphs 8, 12, 19 to 24.
Paragraph 8,
12,
12,
19 to 24. Again, on the proposition that what falls within the scope of we'll just kindly take sorry, 25, not 24. It's 19 to 29, but kindly have a look at paragraph 25.
Outside the jurisdiction of tribunal under Act of 2013, civil court shall have jurisdiction.
Yes, but what is within the jurisdiction, that has to be excluded.
What is outside can be brought.
Yes, and here I've shown they say these are the acts of oppression.
Obviously,
yes.
Because civil cannot be filed, or civil court cannot entertain a suit which a tribunal is empowered to do.
Correct.
When the tribunal is not empowered, there can be
quite naturally. And here I've shown how the suit is framed is to say really reliefs under 241 and 242 itself relates to management and my lord, orders with regard to management, and also my lord, saying, using the word oppression. My lord, just one more judgment, my lord, I want to show. 1993 SCC, my lord, where that question, 1993 SCC. One, two, three. Well, kindly look at paragraph 3.
That is in res judicata.
Yes. No, Mulad, on the question, Mulad, amendment, Mulad, was also considered to be applicable to Mulad pending suits. This is Mulad, again, Mulad, going back to entertain. So the law as it stands now, Mulad, that's what the courts will apply. This is Mulad, the proposition. 3, 8, 9, 8, 9, 10, 11. Mulad, kindly see, Mulad. 9, Mulad.
10, 11.
Yes. 9, 10, 11.
8, 9, 10, 11.
Yes, Mulad, kindly see 8, Mulad, this Mulad comes. The suit in question was instituted on May 6, 1974. That is before the Fifth Amendment was brought into force. Thus, the amendment came into force during the pendency of the suit. Question, therefore, is what is the effect of the Fifth Amendment pending litigation? No provision is made in the Act in that behalf. High Court concluded since there is nothing in the language section 7 and 50 of the Act, primarily welfare legislation to indicate that should be applied retrospectively. There is no question that the application should be necessarily prospective. Proceeding further, the High Court takes the view that even after the Fifth Amendment comes into force, plaintiff had not applied to the Mamlatdar for possession of land within the period sunset and allowed the first become deemed purchaser of the suit. Property on the since the civil court had lost jurisdiction to decide the suit, the High Court dismissed it. We may now proceed to examine whether this view taken by the High Court is correct.
All right, I'll go through it.
Malad, I'm saying even Malad in a pending suit, Malad, the amendment Malad will apply because Malad, it is question of Malad entertaining Malad when the suit comes up for trial. So Malad, those are Malad our submissions. Malad, there's some few more judgments. Malad, we have prepared a preliminary notes. We can file it on the next day, Malad, with all these judgments. Malad, as copies, Malad, we can.
Mr. Mitro, would you start argument today?
Can start with
Of course, it may not be complete today.
I can start.
Yes.
The whole thing is whether section, well, I will not go into the aspect of section 430, whether it completely outs civil court jurisdiction, because there are judgments, there are conflicting judgments. And Mr. Banerjee and I have appeared in matters where judgments have been in our favor, with the Birla matter. Suit is maintainable. Some cases, suit is not maintainable. But the whole issue won't arise because this suit was filed many, many years before the 2007 suit. Substantive law, when it changes jurisdiction, it does not affect pending suits. My rights not only to the jurisdiction of the court, but my right of appeal is also invested on the date I filed the suit. That's substantive law. Unless the law is expressly made retrospective, like a Thika Tenancy Act, expressly made retrospective to affect pending suits. Because this for section 430 has come in 2016 and our suit is 2007 suit. So, well, I'll be basing my case, and also I'm covered by a direct authority of the Bombay High Court on section 430 that pending suits won't be affected. That's also the law because it can't be, it cannot entertain means, does not mean, the language is a party to any proceeding or, sorry, no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or appellate tribunal is empowered to determine by under this Act. Because when we filed the suit, firstly, there was no tribunal. Tribunal was not empowered under this Act. And I will show the earlier law where expressly our High Court was the pioneer in Asansol electric cases in case of oppression mismanagement, what they wanted to cover here. Since there was no section equivalent to section 430, all company law matters, which one could go under section. Now, what is 241? Then it was 397. What is 111? Then now it's 58, 59. one had a parallel right to go either civil court or to the company law board at that time. Okay, kindly, since Mr. Banerjee was citing the judgment, Lordship, can you take the Shashi Khemka judgment? Ache, Shashi Khemka na? Shashi Khemka judgment, which Mr. Banerjee ji just now cited, 2019 18 SCC says the same thing. Kindly see this. Paragraph 6, that says it all. Paragraph 6 of this Shashi Khemka 1918 SCC 569. Paragraph 6, this says it all. This is the law. Paragraph, it is not in dispute. And were a dispute to arise today, the civil suit remedy would be completely barred. Were a dispute to arise today, the civil suit remedy would be completely barred. And the power would be vested with the National Company Tribunal under 59 of the Act. We are conscious of the fact that in the present case, the cause of action has arisen at a stage prior to the enactment. However, we have the view that relegating the parties to suit now would not be the appropriate remedy. Because when was this case filed? This case was filed so relegating the parties to the suit is not the appropriate remedy. Well, I am on this. However, we have the view that relegating the parties to civil suit now would not be the appropriate remedy, especially considering the matter in which 430 is widely worded. So had the dispute arisen today, civil suit is the remedy. So, well, here the cause of action arose 2007 or dates prior thereto. This can never affect the suit. So I, for the sake of argument here, I mean, for the sake of saving time, I would concede here that had this cause of action arisen today, though possibly this will not be covered, I will show. Because the case arising out of family settlement will anyways today also can't be gone to the National Company Law Tribunal. That is covered by judgments. It is a dispute arising out of a family settlement. This is not a corporate dispute as per the law, as laid down in several judgments, including Haldia Petrochemicals, including in cables and several judgments. I will show that even today I can't go to company, but the main line is it is not in dispute that were a dispute to arise today, civil suit remedy would be completely barred. I am on that. So possibly my lord may not have to trouble your lordship with the case where the if today the suit was filed, whether it will be company law tribunal or here, because this suit was filed 2007. And one of the basic laws we all grew up with, we learned in our colleges that jurisdiction is a substantive law. That if a substantive law is changed, unless expressly made retrospective, it will not affect a pending proceeding. I'll be coming on that.
When will you be able to come?
Whenever lordship says, next week, any day, lordship, or whenever my lords.
Any day, my lord, is convenient.
Roster permits, my lords.
Suggest a date.
26, 27th.
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 27. Heard in part, adjourned to 27.
Grateful.
Item number 13.
I appear on behalf of the plaintiff.
What is GA number 3? 3, 11, 13.
There are two GAs I am appearing. Now it is suit number, PLA.
You are plaintiff now.
Plaintiff.
Who is the defendant?
I tell you, lordship, there is some background of this matter. Will left by father and mother both to separately. Will had mentioned that who would be the executor. So executor had filed, as a propounder, my lord, has filed the application for grant of probate. During the pendency of that application, the executor died. There was joint executor, the second executor had filed, then substituted in place of the first executor. Even he died in the meantime. Thereafter, the wife of the second executor is one of the sons of the deceased. She applied for the grant of letter of administration. The letter of administration was granted in her favor. Now, she is today the plaintiff in this matter, number one. Now, when the probate was filed, one of the heirs filed an affidavit in support of his caveat. He was a caveator and subsequently filed the affidavit in support of caveat. Rest of them did not file. During the pendency of this letter of administration, one of the daughters who initially consented, she wanted to back out. She wanted to back out and wanted to file caveat. She filed application. That application, after hearing, was rejected. Subsequently, again, she filed the second application of the similar nature. That was also heard and rejected. So this is the story about the daughter who had initially given consent and wanted to back out. That order stands. Now today, the only person who can be heard by your lordship against this letter of administration is the daughter who had filed the affidavit in support of the caveat. Otherwise, my lord, I have to prove the will and my lord.
Absolutely.
The letter of administration.
Where is that defendant?
That defendant, I don't. We have served.
They never come after filing the affidavit.
It was in all stages. He was.
What about these applications?
Applications for letter of administration.
These GA3, GA11, GA13. 3 applications are pending.
All on, nothing are pending. All are disposed of. All are disposed of. Now only the plaint.
No, 13 is there.
PLA 60 the kunta.
PLA 60 তো মেইন
TS টা কোন TS 7
TS রিনাম্বার হয়েছে
না TS টা আমাদের মেইন
আমাদের
ওয়াইফের না তো বাবার একটা
থানায় আনা সিকপাল
TS 7 and TS 8 are the two suits. It is a contentious cause. It was, my lord, treated as a suit. One is TS 7, one is TS 8.
GA13.
But all disposal, all these.
No. GA13 is leave to be given to re-verify the amended application.
So that was done. That was also done.
In terms of which order?
Well, it has been done. My instruction, it is done. Nothing is pending. No application is pending. No order.
পেন্ডিং এগুলো তো ডিসপোজার দেখাতে হবে ডিসপোজার আছে কিনা
ওগুলো দেখা আমরা কি কেন দেব ডিসপোজার
অর্ডারের কপি আছে সেটা জিজ্ঞেস করছি
অর্ডার গুলো বার করো না আমি কি করে বুঝবো আরে অর্ডার গুলো এগুলো আছে কিনা সেগুলো বার করো because suit cannot be proceeded with unless this 14 stands disposed of.
It has been disposed.
My instruction, it has been disposed of.
Where is that order? 14 is for re-verification of the claim.
Already re-verified.
Verification. May I look at the, Lordship, kindly look at the plaint, whether it has been re-verified or not.
Re-verified. Already.
21-12-23. It has been re-verified on 21st December
23.
Yes. Yes, 21st December 23.
But this application must be shown disposed of.
It must be, otherwise it cannot be done. Re-verification could not be done.
এই অর্ডারটা কোথায়? That is so far as 13 is concerned.
13.
Re-verification is in GA 13. GA 13 of 23 is for re-verification.
My lord.
It is done.
Done.
So far as GA 11?
That is 13 is concerned. That is TS number 7 of 2005, which has been numbered as suit after it become a contentious cause.
Yes, GA 13 is filed in connection with TS 2005, 7 of 2005.
So it has been done and re-verification.
What about this GA 11?
11. Then I'll check it up.
Let me call for a report from the department.
Just a minute. This was re-verified on 20.
13 and 11.
Let me call for a report from the.
Kindly look at the order, my lord, once. If it otherwise convenient, then no.
ডিসপোজ হয়ে গেছে GA 13 আমি যেহেতু কথাটা লিখিনি ওই জন্য পেন্ডিং দেখিয়ে যাচ্ছে and GA 11
My lord, can you see the GA? Both the matters were taken together and disposed of by the common order. Because the petitioner is same.
And what about this GA 3 of 2007?
GA 3 of 2007.
Order copy take pay jabe GA.
So GA जहाँ पे
Whatever order you may write, you have to add one word disposed of. Otherwise, it will be shown pending.
Right, my lord, your option is correct, but unless, my lord, that application was disposed of, those only
Substance of the order is that it is disposed of. Allowing means disposed of. Still, it is shown pending. Because unfortunately, I have not used the word disposed of. Department has kept all these things pending.
The department should have recorded that. Because the order speaks, my lord, it has been disposed of.
Yes.
Now, unless it is disposed of, my lord, there are two applications.
What about GA 3?
He said, GA3, what is the GA3?
আরে GA 3 তো দেখাচ্ছে পেন্ডিং
GA3 টা কি আমি জানেন শুনুন না অ্যাসিস্ট করে দিন না তাড়াতাড়ি করে হয়ে যাবে
The substance of the in substance, the order dated 28 November 2023, GA 11 of 2019 and GA 13 of 2023 were allowed, meaning thereby disposal of both the applications. Full stop. The department should note that. Note the disposal of GA 11 of 2019 and GA 13 of 2023 in terms of order dated 28 November 2023. Department shall submit a report on pendency of GA 3 of 2007 on the next date. If it is disposed of, the date of disposal should be mentioned. Let the report come on 1st March, on 27th February.
And we shall also come of our own, how many
If you
GAs
have, you
were
come
there,
with that.
how many GAs were there, and what
3
are
GAs.
the,
It showed 3 GAs are shown
all
pending.
disposed of. My instruction is all disposed.
Yes, because these 11 and 13 were disposed of in terms of order dated 8.
By your
I'm
lordship, sir.
retaining a copy. I am retaining a copy.
Yes.
So only thing is GA 3 of 2007.
Only thing that is, we'll take it.
If you have a copy of this order, come with that. So we can proceed with the original suit.
Now my London friend appears, my lord. If my London friend is anything to say, my lord, if my London friend wants to say anything, so that I will also come to know.
But my
Client want to say something, she is coming from Hyderabad, it is up to your lordship.
You submit. It is you.
Then I do not have to say. छोड़िए ना, बोल देगा, बोलेगा नहीं.
Your counsel is there.
Story
So I
tell
will
you-
hear from your counsel.
Yes, my lord, I tell you, lordship, the same story.
Let them speak. Let
same
them speak.
Story will be.
All right, let them speak.
No, I beg to be, sir. I do not want to say.
That's all.
छोड़िए. छोड़िए. Much obliged.
Okay. Item.
ওখানে 14 GA 9 of 19 pendency status of GA 9 of 19 in TS 8 of 2005.
Item 15 and 16.
Out of the matter, your lordship. In this connection, I am submitting that in IA number 153 of 2023, though GA number 153 of 2023, though it is not, matter is in the list. On 2nd February, your lordship has passed an order, directed my client to file an affidavit. He has signed the affidavit on 13th of February and he is expired on 16th of February. So
Substitution of fresh application.
substitution is required, so therefore time be extended to file. Or as and when this.
Where is that order? That order was dated
2nd February of this year.
GA 153.
GA 153.
You are for defendant number 24.
Yes.
Defendant number 24 expired.
Expired. He has signed this affidavit. Affidavit is otherwise ready, but he died on 16th of February.
The learned counsel. But GA 153 is not fixed today.
No, no.
It is
My
not
lord,
fixed today.
today is fixed by 149. GA
Because
149.
your lordship has given 15 days time. That is why I am.
All right, that order may be passed. What about 149 and
My lord,
151?
149, my lord, I am for the petitioner, my lord.
Have you served copy?
My lord, it is already your lordship was pleased to pass an order on 2nd February. Well, it is an application for recalling of a lordship's order dated my lord 14 July, my lord.
Yes.
Your lordship was pleased to dismiss or dispose of this application, my lord, with a direction upon the petitioner to pay cost of rupees 25,000 to the to deposit with the original side registrar, my lord.
Yes.
So, my lord, it is your lordship's order on only 2nd February, but it was only in the server, my lord. After that, my lord, we could not.
Extension of time.
My lord, not only extension, my client's instruction is, my lord, we are going to appeal, my lord.
Go for that.
Yes, my lord.
May I file the reports?
Report of?
As directed by Lordship on in the order dated 2nd February 2024. And another report, my lord, for conciliation between the parties which failed.
You are the receiver. What about this 151?
My lord, I want to say something. Time is given to deposit the amount 7 days, but not yet the amount is deposited to the receiver.
Whose application is 149?
151. My application, my lord.
That was disposed of.
Yes, my lord.
Then why it has come in the list?
Is a lot.
This is dismissed and order is given to submit 25,000 to the receiver within 7 days. But not
GA
yet,
149 of 2023
but not yet
was disposed of in terms of. No, এটা তো রিপোর্টের জন্য আমি রেখেছিলাম।
dismiss is
Yes, what is the report of the receiver?
Well, may I file?
May I have a copy of this?
Copy is circulated by
paragraph 2 and 3.
Reports of the learned receivers.
Let a copy be provided.
The learned receiver submitted two reports. One dated 15/12/2023 and the other bearing date 19/2/2024. Full stop. In terms of the receiver's report dated 15/12/23, it is expressed that in the report dated 15/12/23, it is contended that no settlement could be reached between the parties. The report may be kept in record.
My lord, receiver may be directed to serve a copy of the report upon the petitioner also, my lord.
Yes.
All the parties, all the
Because my lord,
In terms of in the report dated 19/2/2024, the learned receivers mentioned that amount of cost mentioned in the order dated 2nd February 2024 was not deposited till the date of filing of this report. Copies of the reports may be handed over to the parties, including the petitioner itself.
my lord.
The developer, petitioner itself, the developer. Full stop. The developer shall explain on or before the returnable date why, in spite of the order dated 2nd February 2024, the order of cost was not deposited before the learned receiver.
My lord, may I make one? My lord, it is uploaded, my lord, after my lord, not
Come with an explanation.
it is not uploaded on
Come with an explanation.
my lord.
My lord, in respect of 151.
GA number 150, your lordship, defendant number 24 expired. And accordingly, I will
come one by one. GF 151.
My lord, this is my application for leave may be granted for filing written statement in respect of the dependent number 12A, substituted petitioner, dependent. Well, only pair for leave may be granted to file an written statement on behalf
When
of the,
summons were served.
Well, on the last occasion, your lordship directed to the registrar to submit a report. On the basis of that, the report has been submitted.
Who is the plaintiff?
Malad?
Who is the plaintiff?
Plaintiff, Malad, today is not absent.
When amended plaintiff was served.
The time, date and time has not been properly expressed by my client. না তারপরে তো
But you have not mentioned when you did receive the service summon,
but
amended plaint.
yes, my lord, that is just what is the substitution has been made.
So how can I allow?
Because
Your application is defective.
I came before your lordship for contesting the partition suit.
Maybe. Delay of 3160 days.
Yes, 3160 days.
Where is the explanation?
In the meantime, I obtain and probate from the will. Well, this is the paragraph 5.
That is not there. You said after receiving paragraph 2, you said deferred on 2017 10 2009, different number 12 expired.
Yes.
Thereafter, different number 12A, 12B, and 12C were substituted.
Substituted in year 2014, paragraph 4.
Yes, 2014.
14.
So, when did you receive the summons?
Well, the particular date has not been properly communicated by my
That
client.
was suppressed.
No, there is no question of suppression, my lord. I subsequently, my lord, came before your lordship with
Summon was served upon you. You admitted that you received amended plaint. That you admitted. But did not mention date. Even the year. I'm not going to the date. Particular date may not be remembered. Even the year is not there. And according to you, it is 10 years. Almost 10 years. 3160 days.
Yes.
What is the explanation?
But the paragraph 5 is my explanation after knowing.
That is no ground. Who barred you to appear here? Was there any bar, any court order? This is your admission. You have received amended statement, written statement, amended plaint. And it is your admission there is a delay of 3160 days.
Yes, well, that may be condoned and given opportunity to.
What explanation is there? What explanation is there?
Kindly come to paragraph 6. Petitioner is suffering from various alignment due to the old age and your petitioner did
Sorry,
not move.
I can't allow this.
That should not be, my lord.
Then you pass the order. Then you pass the order. Why relying on me? That should not be done if it is so.
But a partition suit. I am a substitute dependent. I came with a written statement before your lordship. And your lordship, well, kindly
All right, that's why my suggestion is you pass the order. GA 151 of 2023 is filed with a prayer to condone delay and allow the different number 12A, 12B, and 12C condone delay of 3160 days and allow the different number 12A, 12B, and 12C to file written statement.
No. Only 12A, 12B, 12C, I am not.
12A, sorry, 12A. It is averred that substitution application was allowed sometime in the year 2014 on date of original different number 12. The petitioner was busy. No, petition is the amended plaint was served. Full stop. The petitioner could not take any steps as because the petitioner had been suffering from various ailments. The petitioner was engaged in obtaining probate in OS 2 of 2016, which was ultimately allowed, which was granted on 28/2/22. According to the petitioner, there was a delay of 3160 days. The application did not set out a cogent reason why there was delay of 3160 days from the date of expiry of the stipulated period of filing written statement. Accordingly, the application stands dismissed. GA 151 of 23 stands disposed of.
My lord, may I request one thing? Another application with GA number 135 of 2018.
That is not in today's list.
That is not in today's list, my lord. My lord, it is an application for confirmation of sale, my lord. My client is a senior citizen, my lord. He is the highest bidder. My lord, kindly.
Substitution with
My lord, the substitution is nowhere related.
What is
with-
substitution application?
Substitution application will be filed, my lord. Defendant number 25 has expired, my lord.
My lord,
That is the
in
benefit.
that
has to
in
be
that
carried
case,
out.
my lord, since he is the intending purchaser, my lord.
You are for?
Defendant number 25.
The learned counsel for defendant number 25 submitted that although defendant number 24
25.
25 was allowed to file affidavit in opposition,
Let a copy.
and the said affidavit in opposition was ready from other defendant.
They can serve it.
Could not be filed since the Mr.
Defendant number, he will not, it could not be filed since
Was allowed to file affidavit in opposition, and the said affidavit in opposition was ready.
However, full stop. However, in the meantime, the defendant number 25 expired
16 February 2020.
on 16 February
2020.
2024.
Affidavit was approved on 13 February.
Full stop. This necessitates filing of substitution application. Plaintiff is granted leave to file appropriate application for substitution. Let the matter appear in the list on 13th March, along with GA 135 of
May I just
2018, mal.
May I just
2018.
My lord has kept all other applications probably on the 10th April 2023.
10th April.
10th April 2023. Let all these applications come up along with it. Grateful.
Disposed of. Dismissed and disposed of.
Dismissed.
Item number 17.
Well, this is the application.
Hmm.
I am the defendant in an eviction suit.
GA 17. What about 17?
Item 17. No,
Well,
this,
this is my application for record.
Item 17, GA 17. Both are 17.
Both are seven.
both 17.
Now,
No, this was deposition is over and the suit is ready for hearing.
may I humbly submit, may I first place my, this application is for recording my objections to certain exhibits standard. Whether those documents will be finally accepted by court on merit, that's a different thing. But what question?
G,
If you
G,
lordship
GA, GB, GC.
yes.
And
These are the unregistered, insufficiently stamped deed of lease and the signatures put thereon. I only want, my lord, this should be recorded after, my lord, question number 59 thou just appeared.
একটু record টা দিন।
This application, if your lordship will take it up, my lord, I will respond, or this can be fixed under
No,
the.
no, no, no. I
Let this be disposed of.
yes.
Well, then, my lord, I will.
You will file
respond.
your.
Yes.
I have already.
You have filed your.
Yes, yes. This is affidavits are ready, my lord. Then let it be taken up.
Kindly take, my lord, the deposit.
Now, judgment copy গুলো এনেছো? যেগুলো আমি দেখাবো।
Opposition না document গুলো দাও।
1, 2, 3, 4, 5, ছটা judgment থাকে, huh?
You are referring to question number?
51 to 59. After 59, it has been marked as exhibit.
So G, GA, GB, GC.
Yes.
Along with G by 1, G by 2, G by 3, and G by 4.
Those are signatures. And my lord, please, your lordship, kindly look at. But these were put by your lordship, question of the court. I only want, my lord.
Documents গুলো দেখে।
বলো, তাড়াতাড়ি বলো।
এগুলোকে একটু ঠিক মতো সাজিয়ে রাখো।
Pursuant to the observation and direction given by your lordship, we have inspected the original exhibits. Those are unregistered document, lease for more than lease for 3 years, more than 1 year, has to be registered. And your lordship knows now under the Stamp Act, it has to be sufficiently stamped. My learned friend has taken the point that you have not objected at that point of time. So under 36 of the Stamp Act, it is, you cannot take now. There are other objections. First of all, it is unregistered. Unregistered document, it has to be, your lordship, kindly look at section
Impounded.
49.
Impounded.
No, unregistered. Kindly look at.
It has no evidentiary value.
Except in 2 cases. Suit for specific performance, it is not that. And second one is for collateral purposes. Now, for collateral purposes, I've got Millard, the statutory provisions or other relevant judgments. It is document between A and B. They can rely, but between A and C, in litigation, if A wants to rely that, whether that will be allowed for collateral purpose or not, that is a matter to be argued, and it should be marked, Millard, subject to objection. At this stage, otherwise I will be, Millard, precluded from arguing when the main suit will come for hearing. This is my first submission. Secondly, I cannot, Millard, enter the provisions of the Registration Act unless it is recorded here. Because my learned friend will say it is for collateral purpose. You have not taken any objection. This is the first, Millard, difficulty or hurdle I shall face. Secondly, it is, if your lordship kindly go through the deposition, I am going to the Millard merit. A document executed between X and Y. PW has come here to depose and Millard tender in evidence that document. He has proved, or Millard purported to prove, that he was present when two persons, Millard, signed. He has not proved the truth of the contents of the document. That has to be subject to objection.
Where have you mentioned these points?
Pardon?
Where have you mentioned in your application? এগুলো নিয়ে যাও।
It is not, Millard, I should say. It has been parabolo. Legal provision I need not mention. I say, kindly record this, my objection. These are the legal, I need not, Millard, plead evidence. I need not plead law. I say that it should have been done. Objection should have been mentioned. They want to rely on this document to prove the rate of mean profit. That relates to the contents of the truth of the contents of the document. Para 16 to 19, your lordship kindly look at. Para 17 specifically on registration. Para 18 third party document.
Yes.
Secondly, if your lordship kindly look at two provisions of the transfer of property, here. Section
That is settled law.
7 first.
That is settled law, must be a registered instrument. Must be a registered instrument.
So their case, they ought to be made out that they want to prove the rate of mean profit by relying on this document. Other thing I can take care of at the time of hearing. But unless it is marked as subject to objection, the registration part, section 49 of the Registration Act, if your lordship kindly look at, then I think that will be better. अच्छा registration act down. May I, my lord, hand over a copy of it?
नहीं होना चाहिए।
No document required by section.
These are settled law. Section 14.
No, only the exceptions. My lord, provided that an unregistered document affecting immovable property and required by this Act or Transfer of Property Act 1882 to be registered may be received as evidence of a contract in a suit for specific performance. It is not, or as evidence for a collateral transaction not required to be effected by the registered instrument. Now, the truth of the kindly note, if it is unregistered, you cannot look into it. You cannot look into it for any alleged collateral purpose to prove the rate of rent there. There, if it is not, my lord, my objection is recorded, it will be difficult. Secondly, the other thing is that the person has not proved the truth of the contents of the document.
Right. Understand your point.
Kindly
Come on the
take
next
my-
day. I will hear you on the next date.
This application,
Application.
any day subject to law.
Then, my lord, my learned friend has concluded then.
No, I've got the judge.
No, if necessary, I will hear. Because it is for the court to get clarification, to hear.
But if he wants to rely on judgments, then he will.
Would you rely on some judgments?
The judgments on it will go, my lord, on
Then come on the next day. I will hear you rest. Hard GA 17 of 2024 in part. Fix 28th February for further hearing.
Yes.
28th is okay?
Yes. Lord, one thing, my lord, if it is taken up, my learned friend has no objection under the heading for argument, then my lord.
No, no,
If it is
I'm
not
not,
sorted.
this is not argument. This is only hearing application. I'm
I
not
say
hearing
if
argument of this.
My learned friend agrees to that, I can go straight to argument.
No, no. Argument is different thing.
But the
Let me dispose of
argument-
this application first.
Very good.
I'm grateful to you.
Item number 18.
My lord, I am appealing for the defendant, my lord.
My lord,
This
I'm appealing
matter,
for the plaintiff, my lord.
My lord,
My lord, I'm being led by Miss Urmila.
my lord, in this
My lord,
matter, appeal is pending, my lord. They have filed execution case. They are, in spite of passing of the final judgment, my lord, they have filed a contempt application.
That's up to the appellate court.
My lord, if I may.
So what can I do that?
In the
My lord,
meantime, during the pendency of the appeal, my lord, they have
So go before the appellate court.
My lord, that is with regard to the eviction decree. My lord, this is a suit for eviction and mean profit. My lord, the eviction decree, my lord, they have challenged in appeal. But my lord, in the meantime, on 30th December 2023, they themselves have surrendered the property.
No, my lord, that
My
is
lord,
not
in
the-
our favor. And my lord, the key was also handed over to me.
Since July,
My
my
lord,
lord,
today, my lord, the
it is
scope
on record.
before my lord is with regard to mean profit. On 31st January 2024, it was my lord's pleasure to grant us leave to file a supplementary affidavit. My lord, we have served, my lord, my learned friend, the supplementary
My lord, it
affidavit.
has been served today only,
My lord, we are trying to serve him since 16.
Would you file any?
My lord,
You?
my
All
lord,
right.
objection now.
Supplementary affidavit is filed by the plaintiff in terms of the leave granted on 31st January 2024. Full stop. Copy served. The learned counsel for the defendant craves leave to file affidavit in opposition. Full stop. Affidavit in opposition is to be filed within 1 week, within 2 weeks. Affidavit in reply, if any, within 1 week thereafter.
Obliged.
The suit will appear in the list on 21st March.
Deeply obliged.
Much obliged.
Item number 19.
I appear for
My lord, I am appearing for the plaintiffs.
I appear for defendant number 1,
3, 8,
A, B, C, and my lord.
What this GA21 is about?
For the defendant number 2.
My lord, J21 is the appear for appointment of surveyor commissioner because we are at a variance. And on 29th January 2024, your lordship has been pleased.
For appointment of surveyor commissioner.
Yes, my lord. Because-
Presently, partition commissioners are there.
Yes, all the partition commissioners are there.
So you need a surveyor, independent commissioner and surveyor.
Indian.
Appointed by this honorable court, we are at variance. Any person may be appointed by this honorable court. We are at variance with the in regard to the names that none of the names given by us
Need not be. Let the High Court appoint.
Let the court appoint. That is my humble submission. And
GA 21 of 24 is filed by the plaintiff praying for appointment of a surveyor commissioner for partition. The registrar original site shall appoint one survey commissioner from the list of the High Court panel. Full stop. The learned counsels for the parties submitted that they will accept such appointment by the learned registrar original site. The survey commissioner shall be paid out of joint fund. That a report may be submitted before this court by the learned registrar original site on appointment of the commissioner. Let the matter appear in the list on 7th March. GA 21 of 24 stands disposed of.
Grateful.
Item number 20. My lord, I appear for some of the defendants. I believe my learned friend is appearing for the plaintiff. On the 17th of January 2024, my learned friend submitted that the plaintiff has since passed away, expired.
Substitution application?
He has already filed an application for substitution. We had asked for a copy, which we have not received till today. If he has filed an application, let him give the GA number, let it appear.
No, I'll indicate, my lord. What had happened is we had filed an application, but certain defects were pointed out by the department in as much as it was a notice of motion we had taken out. So the department told us this is not acceptable. You have to take out a master summons. So we are doing that, my lord. The master summons and the along supporting documents have been couriered from Bangalore. They're supposed to reach Calcutta today. So we'll have to formally take out the summons. The master will indicate the date and then I have to obviously serve them. Yes.
My lord, Lordship will, in that event, my lord, Lordship will keep this suit after a week. In the meantime, it should be filed and then
definitely
the matter can be heard.
But may I suggest let it be kept after 2 weeks, my lord? Because I don't know what date the master
Very well,
will
after
begin.
2 weeks. In fact, my lord, we had mentioned this matter on last Monday when your lordship was pleased to direct this matter to appear on the 21st. Now, in view of this development, let it stand over for 2 weeks. In the meantime, let him file that.
Let the matter adjourn to 22nd March, 20th March.
20th March. Very well.
Very well. I'm most grateful.
Hopefully, the things will be done in the
Yes,
meantime.
yes, I would imagine so. They'll come up in the list in the usual course in any event.
My lord, will it be inconvenient if your lordship keeps it on the 19th of March instead of 20th?
19th March, okay.
19th March. I'm so glad. I'm very much obliged.
I'm grateful, my lord.
Item number 21 to 27.
I appear for the plaintiff in these bunch of matters.
I appear for the defendants.
My lord, as far as the first matter is concerned, item number 21, I believe the defendant has died. That is our instruction.
No, defendant has not died. I don't know where my learned friend has got this. I had a word with the defendant. He is alive. Fully alive. My lord will recall these suits have been adjourned on several occasions.
Very well.
On the last occasion, my lord was pleased to say that, my lord, if they are not ready today, it will be dismissed. That's the order, my lord.
My lord,
I find it extremely surprising that this statement is made that the defendant has died.
My lord, I have come to know if my Mr. Anuj Singh is saying with some conviction that his client is alive, I am ready to proceed. No problem. But as far as the other matters are concerned, I am ready to produce. Only, my lord, item number 21, since I have this information, and my advocate on record has also written to his advocate on record.
It's incorrect, my lord. I'm saying it.
Yeah, very well. So we'll proceed. Now, my lord,
You do one thing.
My lord.
You first take out how many applications are pending, a short list of the applications. Number of applications are there. From 21 to 27.
My lord, as far as my instructions goes, these GAs, my lord, have been disposed of. May not be all, but some. I will make a chart and come back to your lordship. My lord, in the meantime, may I only submit this? In this bunch of matters, in some matters, issues have to be framed. In some matters, evidence action has to continue. Already my witness was in the box. And in some matters, evidence has to start afresh. I mean, it has to begin. For the
Come with a
first time.
chart, all these things.
Yes, number one. Number two, my lord, I have had a very informal talk with my learned friend. Since the 7 suits, my lord, voluminous papers are there. Even if I want
What
to...
these suits are about?
Yes. Now, my lord, all these suits your lordship will see, the plaintiff is Calcutta Stock Exchange Limited, my clients. Now, my lord, and all the defendants are, my lord, member brokers of the stock exchange. Now, my lord, they used to trade on the Calcutta Stock Exchange platform. And, my lord, there are several rules and bylaws and regulations of the stock exchange which they had signed and they are bound by. Now, my lord, there are settlements that happen. Weekly settlements, fortnightly settlements. Say a person is trading on the platform day in, day out. My lord, his pay-in obligations and pay-out obligations, that is whatever shares he is buying and whatever shares he is selling, these pay-in and pay-out obligations are settled. It's called a settlement cycle. So after each settlement cycle, either a person has to deposit the shares which he has sold or, my lord, the money for which shares he has bought. Now, my lord, in gist, my lord, all these defendants have defaulted in their obligations, my lord. That's my case. Now, whether I succeed or not is a different thing. So, my lord, Calcutta Stock Exchange has there is something called a defaulter fund. My lord, if there is any default by any of the brokers, we, my lord, fall back on that settlement guarantee fund and make the payouts. My lord, those sums we are now claiming that these were your defaults, you have not paid, and we are to get money on account of these defaults. That is the long and short of the all the
The
suits.
plaintiff's case, my lord. We have a
Same as the
defense.
plaintiff
I'm
case,
not
he
going
has
into
a
case.
defense.
What you have to do,
My lord,
first sort out the case,
my lord,
cases.
with a chart for
Chart.
every, yes.
One chart is for GS.
My lord.
Pending. I am also calling for a report from
My
them,
lord,
from
my
the
lord.
department. Second, how many suits are in the evidence stage? Evidence is going on.
My lord.
Evidence is complete.
My lord.
Evidence are yet to be started.
My lord. We will make
So
that.
I will group these suits together.
My lord.
Very
So
good.
deeply obliged. And my lord, last but not the least, my lord, I have a talk with Mr. Anuj Singh. My lord, if it's possible, since the voluminous records are there and the my witness has to at least go in and prove those documents. If it commences to your lordship, and if my learned friend is agreeable, my lord, now the provisions of Civil Procedure Code has been amended. My lord, my commission is really, my lord, a matter of course. Instead of boggling down the courts with huge evidence, my lord, commissions can be, my lord, also arranged. If my learned friend agrees, we can also, my lord.
That is next question.
Next question. But I'm saying he can take instructions, and he has also agreed to take instructions.
Let first, my lord, let this chart be prepared.
Yes.
And we will come back.
The department is directed to submit এটা 21 থেকে 27 অবধি হবে। Directed to submit a report on pendency of the applications suit in all these pending suits on or before the returnable date. Full stop. Mr. Ghosh, the learned counsel appearing for the plaintiffs.
My lord, I appear in 21 to 26 only.
So 27, somebody else.
I am referring to plaintiff only.
Yes.
Submitted that he will prepare a chart to enable case management easier. Is it all these commercial disputes?
No, no. No.
Check it.
My lord, I will.
Sounds like commercial dispute.
My lord, this is really a transaction. It's an inter-party settlement between the brokers and the stock exchange
Right.
under its bylaws. It's really, my lord, not any agreement. But my lord, there might be a possibility. I will check it.
Agreement maybe.
Maybe. No, I appreciate what
Because
is
basic transactions are commercial.
Yes, has to be. But I'll check and. But my lord, this report is anyway very important that your lordship has directed.
Yes. কি বললাম? Easier. Management of the cases easier.
My lord, my chart is almost ready. So my lord gives 1 week's time. We shall come back.
সেন্টেন্সটা কি বললাম? Full stop. ঠিক আছে. Mr. Ghosh is at liberty to prepare the chart and file in this court on the next date.
My lord, any day apart from 1st March. Any day.
Let the suit appear in the list on 8th March.
It can be before that also if it comes because it's only a question of just finding out, then we can sort out.
5th March.
So deeply.
Very good.
Yes.
Your Lordship, before my Lord takes up, my Lord, item number 32 has been firstly wrongly placed as witness. It will be in arguments. Last day witness said was over.
Would you start argument today?
And the problem is, my Lord, my client's mother died yesterday. She was in hospital, so we could not take instructions. Kindly fix it after 15th of March any day.
Who is your other side? এটা লিখে নিন।
I am for the plaintiff.
On the prayer of the learned counsel for the defendant, argument of the suit is adjourned to 19th March.
And my Lord, another thing, my Lord, there's another suit which is also analogously heard. EOS 1.
1 of 2010, my lord.
When that is fixed.
Well,
Oh, that
it was appearing, but somehow the number is not reflected. It was appearing because it's a 2010 order that these two suits will be heard analogously.
Evidence is complete in that matter?
For that matter, my Lord,
evidence.
no matter, because I'm the plaintiff, they are the defendant. They chose not to file any.
My lord, his suit is for a declaration of tenancy. Now that is a purely legal issue.
Let that matter come appear on this.
The same day.
The suit will appear in the list along with
EOS 1 of 2010.
There's also an order passed by my lord the Chief Justice saying that
That matter is
EOS 1
also
of 2010 will be heard by my lord.
2010. তো ছিল লিস্টে, একটা বেরিয়ে গেল কি করে জানি না।
ডেট কবে দিলে? 19th March.
19th March. My Lord, নামটা দিয়ে দিস।
Well, before your lordship takes up, may I have your lordships kind leave to mention item 33?
I'm appearing to the defendant in this matter.
In this matter, we had indicated on the last occasion that we would apply for appointment of a commissioner for the purpose of recording the evidence. Now, what has happened in the meantime is we've affirmed the application, served it on my learned friend. When we went to file the application, it appears that this suit has been marked as a commercial suit, which it cannot be. It has been marked.
Yes, why it is commercial suit?
I don't know, Milord. It's purely a suit under Section 6 for recovery of possession. It does not qualify as a commercial dispute.
এটা অর্ডার হয়েছিল নাকি?
No, no, this has been done.
তাহলে
Across board, all suits were made marked.
একটু প্লেনটা দাও।
দেখে দিন না।
Application, print wait.
Basically family dispute.
Yes. Section 6 for recovery of possession. Declaration, injunction, and recovery of possession. And it's not a commercial, it's a residential.
In family members.
Yes, I have said it was my residence, so there is no commercial aspect at all. Your lordship will have to make an order saying that this will not be a commercial cause. And your lordship, I would seek leave, my lord, to permit me to file the application, because the department is saying get leave from the honorable court that it can be filed as a non-commercial.
I am passing order.
Yes.
এটা কত নম্বর দেখাচ্ছ? কবেকার লিস্ট? অ্যাপিলেট সাইডের কোথায়? এখানে তো নেই। The instant suit is renumbered as CS-com/46/2024. This is a suit between the members of the family for recovery of possession, declaration, and other relief. Suit between the members of a family with prayers for declaration, injunction, recovery of possession, and others. The suit should be reconverted into an ordinary suit subject to original ordinary civil jurisdiction. And the same should be transferred from commercial division to the ordinary jurisdiction. Full stop. The registered original site shall not, without the registry shall not, without order of this court, convert a suit to a commercial one or reconvert the same, or convert a commercial suit to an ordinary suit. Copy of this order may be sent to the registrar original site. As well as to the registrar of insolvency. The suit shall appear in the list on your argument is you just
no. We are to examine our witness. So we are taking, but the suit may appear whenever your lordship comments. The application will appear on 26th.
Application for
appointment of a commissioner. So it can appear on the 26th, of the suit.
26th February.
Obliged.
28.
Your lordship, item 30.
30, my lord.
Yes.
Miss Item 30, my lord, I am praying for an accommodation. My lord, last evening, the mother of the plaintiff has passed away. My lord, kindly adjourn it for at least 15 days, my lord.
On prayer of the learned counsel for the plaintiff. Plaintiff. The suit is hearing is adjourned to 11th March. 30.
30.
I'm for the defendant here.
Item now 28.
I am appearing. I am appearing for the plaintiffs in this case. Lastly, everything is completed, evidence, etc., has been taken. Lastly, the defendants raised a point that this suit is not maintainable because in the meantime, an award has been passed. And
I was hearing argument, and so I want to hear the argument.
Argument on the point of maintainability.
No. Argument on merit as well as maintainability. You are not aware of the suit. Defendant's argument is complete. Now the plaintiff's argument.
May I just interrupt? May I take my
Yes.
No, subject to correction, my lord, Mr. Dotto was making submission with regard
That
to
is
the
done.
maintainability of the suit, only with regard to the maintainability. Thereafter, he will.
No, Mr. Dotto argued on.
Subject to correction, my lord, the lordship will kindly.
No, what will you argue? What will you reply? That's up to you.
No, my lord, he had only made submission.
If he had that thing, I have never said that I will hear
He
only on.
did not make any submission subject to my lord. What
He will not do. That's up to him.
Absolutely, absolutely. Then on the
I will
point
hear
of-
you. His argument is closed. I will hear you now.
তাহলে নো মেনটেন দ্যাট মেরিটে বলছি তো মেন
Minutes
মেরিট
এ কিন্তু উনি বলেননি এখন।
You understand? I
Why is my learned friend not telling the correct facts? I had addressed your lordship thoroughly on the question of that the suit is not maintainable, it's a land acquisition proceeding. But that's a question of merits. And my lord was pleased
That
to
is merit as well as maintainability.
and your lordship was pleased to observe that if it's a question of maintainability, then we will hear them. If your lordship is satisfied that the suit lies in this court, then your
Both
lordship
things
will
will be
hear
heard.
Mr. Chatterjee first.
Whole thing will be heard together. You have argued on that point. Now I have to hear reply.
Yes, so your lordship wanted to cut short the matter, and Mr. Chatterjee was asked to address on that point what I have already argued.
Yes.
That is my lord. That is the my lord.
I have not raised
Lord,
any
only with
separate
regard to the
issue.
maintainability issue first, my lord.
I will hear on merit as well as maintainability.
Absolutely, my lord.
Last couple of 3 days matter was not heard.
They did not make any submission with regard to the maintainability of my lord, with the merits of the suit.
Do you want that I should close it?
No, my lord, that is not the.
When will you come? I'm giving you 3 days time. Come and argue.
Lordship, my senior is there. Lordship will kindly allow.
But kindly, in that case, my lord, I make to understand that your lordships will be going to hear the maintainability of the.
I will hear the matter on merit. I'm here. I've never passed any order that I will hear it on maintainability
But
point.
in that case, my lord, I have no problem. Kindly adjourn the matter for some time, my lord.
How many times should I adjourn?
No, my lord, because today I have.
Is your failure to understand?
Understand.
How many times should you fail? How many times
My lord,
plaintiff will fail?
Next time I will not fail.
I'm fixing on Wednesday. Come.
My lord, Wednesday, my lord, there is.
I will fix. I will close your argument then.
My lord,
It's a very old suit.
Kindly, another one day or Thursday or like that, Thursday or Friday.
On prayer of the learned counsel for the plaintiff, argument is adjourned to 22nd February.
You are.
This is right time that I should close your argument.
Kindly pardon me, my lord. My lord, I was instructed, my lord, to make no problem, my lord. We'll proceed on 22nd.
There cannot be compartmentalization of an argument. Next.
Item number 29.
My lord, I am for the defendant in the suit.
Who is your other side?
My lord, I am for. My lord, I am for the petition. Plaintiff.
Not petitioner, plaintiff. Use microphone.
Your lordship will recall this is that suit where, my lord,
Section 88.
yes, one of them were given life interest and the right to sell. And there is a second clause which says if, my lord, this thing doesn't take
I
place.
remember.
Yes. So, my lord, my learned friend, essentially I had argued 3 points. My lord, first point was that, my lord, there is a previous suit before the city civil court which was filed by the same plaintiff against some of the defendants. Essentially, the subject matter of the suit was essentially the
You are
same.
plaintiff.
I am for the defendant. One of the defendants, I am the purchaser of the property from Shonamoni Shaha. According to them, Shonamoni Shaha only had life interest and did not have right to sell. So
Your
the
first argument was there was no leave was taken, or no leave was granted.
no
by the
leave
city-
was taken to withdraw without any leave to file a
file afresh.
Yes.
Non-joinder party. that was your
Non-joined.
play.
Second point was, so I say that this present suit is bad because you did not get that leave, neither you prayed for that.
That is
leave.
one first point number
First point. To that, my lord, they have, my lord, only said that one decision they have cited. I'll come to that later.
Their point is that was the injunctive relief when sale was not yet to be done. Now, after sale, this suit is
correct. Now, to that, my answer is in cross-examination of the plaintiff's only witness, the plaintiff has admitted to a pointed question put by myself that whether before the filing of the city civil court suit, whether you had knowledge of the conveyance being executed. He has answered yes. So, my lord, my argument was that you have chosen not to include the question of rectification of the deed or cancellation of the deed, but you are aware. So, my lord, principles of constructive res judicata will apply. Not only res judicata, but constructive res judicata will also apply. You could have made those prayers, you chose not to make it, and hence, when you have withdrawn that suit without leave to file afresh, this present suit is barred. That's number point. I will deal with their case later. The second point which I argued was Shonamoni Shaha's death. After Shonamoni Shaha's death, no substitution of all the heirs of Shonamoni Shaha have been effected by the plaintiff. Some heirs, the son, is there on record. But your lordship knows, if a Hindu female dies intestate, all the legal heirs, including sons and daughters, have to be made parties. My lord, that has not been done. So I had cited one decision saying that if that is not done, all the heirs of a party is not brought on record, and it can be shown that those people who have not been brought on record may have a say or an interest in the question that ultimately your lordship is going to decide, then their presence is absolutely necessary. And if they have not been implemented, the suit is liable to be dismissed as a whole. Because kindly, my lord, bear with me for a moment. Say, my lord, my learned friend, the plaintiff. What is the plaintiff saying? Plaintiff is saying Shonamoni Shah had no right to sell the property. Now, if your lordship is
লিস্টিং এ অরিজিনাল সাইটে কে দেখে? লিস্টিংটা কে দেখে এই পাগলামোগুলো? অরিজিনাল সাইটের কে আছে? হ্যাঁ, ইয়ারকে ডাকো তো। সিভিল অর্ডিন্যান্স সিভিল মামলা কেন চেঞ্জ? কদলকে ডাকো। Yes.
My lord,
what happens? Problem is that ordinary civil suits are transferred to commercial division. Go through the today's list, cause list.
Oh, my lord,
most of them are ordinary suit.
Yes, like this is an ordinary suit.
Yes. Now, suddenly you will find this is transferred to commercial division
Without an order from your lordship or without
anything else.
That original side listing, my lord.
Yes.
The register original side listing has to be.
Why it is being done? This court will say, look, this is a commercial matter. Looking into the plaint,
goes without
and then court pass order.
Court has to pass a reasoned order after going through the records. Yes. And yes, this is commercial or non-commercial. Now, my lord, the point was, my lord, say for example, if the plaintiff is saying in this suit that Shonamoni Shah did not have any right to sell the property to my clients. Say for example, your lordship decides in their favor that yes, Shonamoni Shah did not have any right. So the money that Shonamoni Shah had taken, there's a consideration which we paid Shonamoni Shah. Now that must have gone to all the if she has died in interstate, then all the legal heirs must have are liable to the extent they have inherited the money or the property or the shares. Now, my lord, if they are not on record, how will I recover? How will I recover? My lord, this is why, my lord, we had, my lord, made the submission and cited that judgment which says that if in this kind of a situation where ultimately what the court decides will involve their interest also of the people who are not on record, then, my lord, the suit as a whole must abate. Now, my lord, my learned friend had cited a judgment which essentially, according to him, my lord, says two things. He has relied upon Order 22, Rule 4, Sub-Rule 4. He says that if any defendant has died without filing a written statement, my lord, court may dispense with the formality of substituting that defendant in a suit. Now, my lord, first and foremost, that to reply to that, my lord, I am saying it's a discretion of the court. It is not automatic. That's why the legislature is very careful in choosing the word may. Number one. Number two, he has cited a decision which also says that leave has to be obtained from the court. leave has to be obtained from the court if a plaintiff feels that I am not going to substitute the defendant because the defendant has not filed his or her written statement. It's their case that Shona Monisha did not file her written statement. Hence, we are exempt from substituting her defendants. No, that is not the law. The judgment also they have cited. My lord, the judgment also he has cited clearly says leave is required. The second point he has argued with regard to this point is that no application is required. That for a leave under order 22 rule 4 sub rule 4, no application is also required. It is oral. Now, my lord, my submission is the judgment cited by my learned friend also nowhere says that no application is required for a leave under order 22 rule 4 sub rule 4. It just says leave can be granted. I'm also saying leave can be granted, but whether that leave was granted, whether any application was made by the plaintiff before your lordships or your lordship's predecessor in this.
Example, order 7 rule 11.
My lord.
Order 7 rule 10. Court shall.
Court shall. Exactly.
That means without waiting for an application.
Obliged. But here it's first of all may, and the may is upon, my lord, an application being made. The judgment cited by my learned friend nowhere says that no application is required under order 22 rule 4 sub rule 4. Kindly takes order 22 rule 4 sub rule 4 once. Kindly takes order 22 rule 4. What are they? 4A says, I'm sorry, 4. The court, whether it thinks fit, may exempt the plaintiff from the necessity of substituting the legal representatives of any such defendant who has failed to file a written statement or who, having filed it, has failed to appear and contest the suit at the hearing, and judgment may in such case be pronounced, again may, double may, be pronounced against the said defendant notwithstanding the death of such defendant, and shall have the same force and effect as if it has been pronounced before the death took place. Now, two things. One, my lord, court has to apply its mind. So, my lord, it is very evident court has to apply its mind that the defendant has not filed a written statement, or that the defendant has filed a written statement but has not appeared thereafter. Then also there is another further may, the court may exempt. Now, my lord, kindly visualize a situation. If these two factors have to be considered by a court before granting any leave to the plaintiff not to substitute, there has to be an application. There has to be an application bringing forward all these material before your lordships.
So, according to you, the court is not supposed to know who has
exactly,
died.
and it's not a rubber stamp. It's court. Our courts are not rubber stamps that the moment somebody says, makes an oral prayer, the court will say, yes, I'm exempting you. These factors are to be weighed by the court, and then the court is going to come to a conclusion, yes, I'm giving you a leave. Now, kindly see the order by which, my lord, they say the only order which I found relevant is an order of 19 November 1996. I don't know whether your lordship's file will have this. Copy chilo to. Kindly gives me one moment, my lord. I think I have the order. একটু দেখুন না নভেম্বর 1996 এর কোনো অর্ডার আছে কিনা অর্ডার শিটটা আছে অর্ডার শিট গুলো আছে হ্যাঁ অর্ডার শিট নেই
90, the order sheet of 96 is not supposed to be here. Even not in the server. Anyway, you
kindly gives you one moment. My lord, may I hand over a copy of the order, my lord? I'll take back, my lord, that bunch, my lord, but the order is there. Kindly see November.
It's 1811.
Yes, 18/11/1996. Shamrakshan advocate appears and submits. Interim order dated 28th March 1996 stands confirmed. Liberty is given to the respondents to apply for variation and or modification of the order upon notice to the plaintiff. Now, very important. It is stated on behalf of the plaintiff, that is grandmother who is defendant number 3, has died during the pendency of the suit, let the name of the said defendant be struck off. Let the copy of the death certificate of granted by CMC Health Department recording the death of the said defendant be kept on record. All parties to act on a signed copy. Defendant number 3 is Shunamani Shah. Now, my lord, here, even if I assume that any oral leave has been given, my lord, first of all, this is not the oral leave under Order 22, Rule 4, Sub Rule 4. No facts have been stated that defendant number 3, the grandmother, has died without filing the written statement or has filed the written statement and has not contested. Hence, I am seeking for a leave. Kindly grant me leave. Number 1. Number 2, no application has been cited by the plaintiff. Nothing has been brought on record and shown to your lordship that any application in this regard had been filed. The only order which comes close is this order, where simpliciter, they have reported the court that defendant number 3 has died and the court has asked the name to be deleted. That's all. No application, no court has not even been invited, in my respectful submission, to grant or not grant any leave under Order 22, Rule 4, Sub Rule 4. No application, not even an invitation to the court that defendant number 3 has died, defendant number 1 has died without filing a written statement. Hence, kindly allow me only to delete. No substitution. Nothing. He has not even addressed this point. We have found out this order, and my lord, we are placing before your lordship that this is the conduct. No application under Order 22, Rule 4, Sub Rule 4. No leave under Order 22, Rule 4, Sub Rule 4. This order cannot be said to be a leave under Order 22, Rule 4, Sub Rule 4. This is simpliciter striking off of the name. No application of mine, no facts stated to the court for seeking the leave. Not recorded, at least not recorded here. This cannot come to their rescue. In this regard, I had cited the case, 1962 Supreme Court, which my lord says, I'll tell your lordship. I think I've handed over a copy also, my lord. 6, 5, and 6. My lord will find this case, my lord, with my notes. I mean, these notes. I'll দেখুন তো একটা notes আছে কিনা, written notes. না, this is on behalf of the plaintiff. Defendant টা দেখুন তো। এক মিনিট দেখি, জাজমেন্ট গুলো আলাদা করে দিলাম এখানে। Defendant number 3A to 3B এর একটা দেখুন, 3A to 3 এর একটা দেখুন তো, ওইটাই হবে বোধহয়। দেখুন দেখুন দেখুন, plaintiff এর। Maybe we have missed out giving the notes. I'm just my lord, this case I had cited 1962 2 SCR 636. Your lordship will have that. Yeah, 1962 Supreme Court, page 89. My lord has the judgment. (1962) Supreme Court, page 89. পেরেছেন? 62 Supreme Court দেখুন, AIR 1962 Supreme Court, page 89. আর কোনো জাজমেন্ট নেই? না, ওনারা তো দেবেনি, আমাদের যেগুলো দেয়া ছিল আমরা সব এগুলো দিয়ে দেখিয়েছি জজ সাহেবকে। (62) Supreme Court, page 89. State of Punjab versus Nathuram. Lord, this I have already cited, my lord. Kindly see paragraph 3 first page only, paragraph 3, last, well, 2 or 3 lines. It starts from there. The state government appealed against the award to the High Court of Punjab. During the pendency of the appeal, Labhu Ram, one of the respondents, died. The High Court holding that the appeal abated against Labhu Ram and that its effect was that the appeal against Nathuram also abated, dismissed the appeal. It also dismissed the cross objection. The state government applied for a certificate of fitness of the case for appeal to this court, and the High Court granted it. As such, questions of great private and public importance were involved. Now, paragraph 4. It is not disputed that in view of Order 22, Rule 4 Civil Procedure Code, hereinafter called the Code, the appeal abated against Labhu Ram, deceased, when no application for bringing on record his legal representatives had been made within the time limited by law. The court does not provide for the abatement of appeal against the other respondents. Court have held that in certain circumstances, the appeal against the co-respondents would also abate as a result of abatement of the appeal against the deceased respondent. They have not been always agreed with respect to the result of the particular circumstances of a case, and there has been consequently divergence of opinion in the application of the principle. It will serve no useful purpose to consider the cases. Suffice it to say that when Order 22, Rule 4 does not provide for the abatement of appeal against co-respondents of the deceased respondent, there can be no question of abatement of the appeal against them. To say that the appeal against them abated in certain circumstances is not a correct statement. Of course, the appeal against them cannot proceed in certain circumstances and have therefore to be dismissed. Such a result depends on the nature of the relief sought in the appeal. So, not only has my submission was, not only has the appeal, my lord, abated against defendant number 1, the original defendant number 1, because of non-substitution of all the legal heirs. Because of their non-substitution, the suit against my clients has also abated and cannot be proceeded with. Why? The Supreme Court clarifies, my lord. The same conclusion is to be drawn from the provisions of Order 1, Rule 9 of the Code, which provides that no suit shall be defeated by reasons of misjoinder or non-joinder of the parties, and the court may, in every suit, deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. It follows, therefore, that if the court can deal with the matter in controversy so far as regards the rights and interests of the appellant and the respondent other than the deceased respondent, it has to proceed with the appeal and decide it. Now, very important, it is only when it is not possible for the court to deal with such matters that it will have to refuse to proceed further with the appeal and therefore dismiss it. The question whether a court can deal with such matters or not will depend on the facts of each case, and therefore no exhaustive statement can be made about the circumstances when this is possible or is not possible. It may, however, be stated that ordinarily the considerations which weigh with the court in deciding upon this question are whether the appeal between the appellants and the respondents other than the deceased can be said to be properly constituted or can be said to have all the necessary parties for the decision of the controversy before the court. The test to determine this has been described in diverse forums. Court will not proceed with an appeal when the success of the appeal may lead to the courts coming to a decision which will be in conflict with the decisions between the appellant and the deceased respondent, and therefore which would lead to the courts passing a decree which will be contradictory to the decree which had become final, not very relevant. B, when the appellant could not have brought the action for necessary reliefs against those respondents alone who are still before the court. And C, when the decree against the surviving respondent, if the appeal succeeds, be ineffective, that is to say, it could not be successfully executed. I am saying B and C would also apply here. Because, my lord, the plaintiff could not have, my lord, instituted the suit only against, my lord, my clients. It had to institute the suit against Shonamoni Shah, or if Shonamoni Shah was not there, against all her heirs. And lastly,
because it will affect the title of all others.
Yes, and my lord, say for example, Shonamoni Shah has taken money from my clients. If your lordship says the sale is bad, conveyance is my lord set aside, then that money has to be paid back, and that money has to be paid back by all the legal heirs of Shonamoni Shah. The daughters are not there only. The daughters have not even been attempted to be substituted. So, my lord,
They have to be settled with financial liabilities
in case
behind their back.
Yes, if your lordship is in favor of the plaintiff and the my lord, conveyance is set aside, I have a right to claim back the money from all layers. Now they will simply come and say, we were not parties in the suit. Our interest has not been protected. Why should we pay you? And my lord, kindly also my lord, bear me on this point that they may have some say. If they were substituted, these daughters of Shonamoni Shah, who are legal heirs of Shonamoni Shah, had a say to either, my lord, support the plaintiff or support the defendant. They have been deprived of that support, they are deprived of that right at the choice and whims of the plaintiff. The plaintiff did not even tell the court that order that I showed. The plaintiff did not even tell the court that there are daughters and sons of the defendant number one who needs to be substituted, but for the fact that Shonamoni Shah did not file a written statement, I am seeking leave of the court not to substitute them. That leave has also not been obtained. So why will your lordship allow this suit to be decreed in favor of the plaintiff who has not done its basic duty of informing the court that defendant number one has died and she is survived by these many legal heirs, and I either want to bring them on record or give them leave. Give me leave not to substitute them. And they have a vital interest in this suit. And no answer to this decision. No answer to this decision. No answer to this point. This order has not been shown to your lordship of my lord 8 November 1996.
18th November.
18th November. My lord, may I file a copy? I have a fresh copy, my lord. Kindly takes it on record. Now, my lord, as far as the other 2 points are concerned, that is, my lord, the point of, my lord, that suit being filed in city civil court and, my lord, no leave being obtained, and, my lord, the other decisions that my learned friend has cited with regard to section 88. My answer is, my lord, section 129 and 130 of the Indian Succession Act. And, my lord, my lord, kindly gives me another date. I will conclude on that day. I'll bring my notes also.
Heard in part, adjourned to? How many days will you take?
1 week, my lord.
29 February.
My lord, sorry.
29 আর কিছু আছে? কি আর্গুমেন্ট আছে? হ্যাঁ হ্যাঁ বিনা দেবী এখানে আর্গুমেন্ট আসবে না 29
I'm sorry.
Hopefully argument will be finished on 29.
I bring my notes also, I will conclude on that day.
No further reply.
No.
Your lordship, new points have been taken in the reply. Your lordship at least allows us to deal with those points. Of course, we won't deal with the facts and all those arguments we have made, but the new points we will show that and order, yes, that order, and there are few.
Witness action. Item number 31.
Item number 31, I appear for the defendant. My lord will recall that application which we filed.
Your lordship, I'm appearing for the plaintiff.
We have, my lord, filed an, under the instructions of the client, we have filed an appeal. That has been, my lord, in the list.
Is there any stay?
It has been served.
There is no stay, your lordship.
We have not been able to move, my lord. We have also mentioned the matter, my lord. Kindly adjust this.
Come on the next date. If there is no stay, I will proceed.
Yes, yes, but kindly give us some time, my lord, at least.
Lordship, kindly give a short date.
Yes. Kindly give
Adjourn to 7th March.
Well,
Milord, already adjourned it, but Milord, I would only pray for Milord because there is no stay. They have not asked for any stay.
All right. Let them bring a stay order. If they are not able to bring a stay order, I will proceed.
On 7th March, they kindly record that on the 7th March, the witness should be directed to be present, Milord.
Yes.
Their witness should be directed to kindly record it, Milord. The witness should be directed to be present,
my
Milord.
lord, if my witness is not there, your lordship will close the witness.
Kindly record it, Milord.
No, why should I direct?
Try my luck in the
Right. Why should I direct the witness to be present? If
Because it was due for that. It was due for that. It was
If
due
if
for
he
the
choose
examination
not
of
to
the.
appear, if he choose not to appear,
Yes.
I will close it.
Kindly record that, my lord, if the in
Not
case
right
he
now.
doesn't appear. Wait, my lord. What did the bulletin kind of?
এলো না তো?